This is the brief on Philippine crimes against chastity. This legal syllabus breaks down how Philippine penal law defines and prosecutes sexual offenses, revealing how legal standards of chastity and personal boundaries operate in the country. First, the gender divide in marital infidelity is wild. Adultery is committed if a married woman simply has relations with another man. But concubinage, which is committed by a married man, requires much more, like keeping a mistress in the conjugal dwelling, cohabiting elsewhere, or acting under scandalous circumstances. It's kind of like a referee giving one player a red card for a simple foul, while the other only gets carded for making a huge spectacle. Why do you think the legal burden differs so wildly? Second, let's look at consent versus deceit. Simple seduction involves a minor who actually consents, but it's invalidated because it was won through deceit, like a fake marriage promise. Acts of lasciviousness, though, involve lewd physical acts, like unwarranted kissing or fondling, committed against someone's will using force or intimidation. So what does this all mean when consent is just an illusion? It really highlights the difference between physical force and psychological manipulation. Finally, there's the modern evolution with the Safe Spaces Act, or Republic Act No. 11313. It aggressively targets gender-based sexual harassment beyond the workplace, penalizing things like catcalling, wolf whistling, persistent unwanted comments, and online harassment. Isn't it wild how a traditional legal framework has stretched to literally outlaw catcalling on your morning commute? Ultimately, the Philippine legal framework is a fascinating mix of strict, gender-traditional rules and progressive modern protections against everyday harassment.
A man violently grabs a woman by the arm in a dark street and forces her toward a waiting vehicle. To an observer, the reality of the situation seems obvious, an abduction in progress. But to a judge analyzing Philippine criminal law, that physical motion, isolated from context, is legally meaningless. Depending entirely on the offender's internal motives, this exact physical act could be prosecuted as grave coercion, forcible abduction, kidnapping, or acts of lasciviousness. Title 11 of the Revised Penal Code, covering crimes against chastity, operates on a hidden framework. The physical contact is secondary to the specific intent, the environmental circumstances, and the relationship between the parties. To correctly classify these offenses, we have to build a definitive, interlocking legal decision tree. This model filters the raw facts of an incident through three specific parameters: evaluating the presence of lewd design, the intent to penetrate, and the power dynamics between the individuals involved. Rote memorization of the penal code fails when fact patterns blur together. Legal practitioners navigate these cases by applying this exact sequence of deductive logic. Classification in Title 11 relies on determining which of these hidden motives drove the physical act. This flowchart begins with a root node, an overt act executed with force or intimidation. The matrix immediately splits based on internal motive. Proof of animus lasciviendi, lewd design, is the first requirement. Without this intent, the act falls outside crimes against chastity. Apply this filter to our opening scenario of the man dragging the woman to the car. If the taking is executed without lechery, perhaps to force her to pay a debt, the charge is grave coercion. But if that identical taking is motivated by unchaste designs, the charge becomes forcible abduction under Article 342. Because intent is an internal mental process, courts cannot observe it directly. Lewd design must be inferred entirely from the environmental circumstances surrounding the act. Consider two cases featuring the exact same physical aggression, a forced kiss and embrace. In People v. Unuevo, the offender attacked the victim inside a well-lit Catholic church with a crowd present. The Supreme Court ruled that the religious atmosphere and public visibility negated lechery. The charge was reduced to unjust vexation. Contrast this with U.S. v. Gomez. The exact same forced kiss occurred in a dark theater while the audience was distracted by the screen. The hidden environment proved the lewd design, resulting in a conviction for acts of lasciviousness. In these cases, the physical location dictates the legal character of the conduct, distinguishing a public annoyance from a severe assault on chastity. Zooming further into our flowchart, we track only the cases that successfully clear the lewd design filter. The next deductive step isolates the offender's ultimate goal. Was the lascivious act the final objective, or a preparatory step towards sexual intercourse? If the overt acts demonstrate a clear intent to penetrate, like removing clothing or mounting a sleeping victim in People v. Tayaba, the crime crosses the threshold into attempted rape. Defense attorneys argue a lack of penetration should downgrade a rape charge. The standard in People v. Ibarra dictates if the offender had full opportunity to copulate, but voluntarily stopped at surface-level acts, the charge drops to acts of lasciviousness. There is a vital statutory quirk here. Acts of lasciviousness only admits of one stage of execution, consummated. Because the final objective is the touch itself, there is no attempted or frustrated stage. The boundary line between attempted rape and acts of lasciviousness rests on a single data point, whether the offender voluntarily abandoned the ultimate physical violation. We can plot these crimes on this new coordinate matrix. The y-axis tracks geographic movement, legally termed taking away. The x-axis tracks the offender's method, force versus consent or deceit. Any taking away of a woman driven by lewd designs is classified as abduction. In the top left quadrant, if the victim is taken against her will, her age and reputation are immaterial. The crime is forcible abduction. Shifting to consent, the fact a victim agreed to leave does not grant immunity. Consented abduction under Article 343 has strict parameters. She must be 12 to 18 years old, a virgin, and consent must result from cajolery. In this context, the Supreme Court does not interpret virginity purely as physical intactness. It refers to a virtuous woman of good reputation. This quadrant contains a strict liability exception, the under 12 rule. The law views a girl under 12 as possessing no will, incapable of valid consent. Even if she joyfully goes with the offender, the law automatically reclassifies the crime back to forcible abduction. In abduction cases, geographic movement magnifies the severity of the intent. It turns a crime against chastity into a dual assault on both sexual purity and physical liberty. Returning to the matrix, we analyze the bottom quadrants. What happens when there is no taking away, but the offender achieves sexual intercourse through manipulation? Crimes committed in place through deceit fall under seduction. The law divides seduction into two distinct tiers, evaluated purely on the power dynamic between the parties. Qualified seduction, under Article 337, occurs when the offender holds a position of moral ascendancy, like a teacher, guardian, or priest. In these relationships, abuse of the trusted position implies deceit automatically. Simple seduction, under Article 338, applies when no special relationship exists, and the offender manipulates the victim using an unfulfilled promise of marriage. Republic Act 11648 introduced a critical update to this tier. The legal emphasis shifted entirely. Prosecutors no longer have to prove the victim had a good reputation. They only need to prove the strict statutory fact that the victim was a minor, aged 16 or over, but under 18. Seduction provisions are designed to punish the weaponization of trust. The law recognizes that psychological deceit achieves the exact same violation as physical force. Practitioners often hit a blind spot when they try to force modern workplace scenarios into the older frameworks of the Revised Penal Code. Looking at our complete decision tree, Republic Act No. 7877, the Anti-Sexual Harassment Act, acts as a statutory override. In employment, education, or training environments, physical touch and carnal knowledge are no longer required to commit a severe offense against chastity. The gravamen of RA 7877 is leverage, the mere demand, request, or requirement of a sexual favor by someone holding moral ascendancy constitutes the crime itself. It is entirely immaterial whether the victim accepts or rejects the demand. The offense is consummated the exact moment the power dynamic is exploited. The final framework organizes these offenses by weighing intent, environment, and relational power to determine the specific criminal liability. A physical act that looks identical on a security camera transforms legally based on the answers to these deductive questions. Mastering criminal law, too, means isolating the invisible animus lasciviendi and mapping the strict statutory parameters.
Welcome to This Explainer. Today, we're diving into a really fascinating and honestly highly specific area of Philippine criminal law. We're looking at crimes against chastity, harassment, and exploitation. And you know what's wild? As we go through this, you'll quickly see that in the eyes of the law, missing just one tiny element, like a specific intent, an exact age, or literally just the lighting in a room, can completely change the crime. Or it could mean there's no crime at all. Let's get right into it. So, here's our game plan for today. We'll be covering marital infidelity, lasciviousness and seduction, defining sexual harassment, child exploitation, and finally, the laws on abduction. All right, let's start with Section 1, marital infidelity under law. Specifically, we're looking at adultery versus concubinage. Okay, so right off the bat, the legal threshold for conviction here is vastly different depending on gender. It's a pretty stark contrast. For a married woman, adultery is consummated by a single, isolated act of sexual intercourse with a man who knows she is married. That's it. But for a husband, a single act of infidelity doesn't automatically trigger a crime. To actually be charged with concubinage, he has to meet some much more strict, highly specific behavioral criteria. Now, you might be wondering, why on earth is there such a massive difference? Well, the Supreme Court case of U.S. versus Mata gives us the historical rationale for this. Historically, the law was fundamentally designed to protect the family line from the danger of introducing, as they put it, spurious heirs. Basically, the biological possibility that a husband might be tricked into financially supporting a child that isn't his. That is exactly why a single act triggers the adultery statute for a woman. So how exactly does a husband commit concubinage? Well, he must commit one of three very specific acts. 1. Keeping a mistress in the conjugal dwelling. Literally bringing her into the family home. 2. Having sexual intercourse under scandalous circumstances that actively offend the community's morals. Or 3. Cohabiting, which means dwelling together as husband and wife somewhere else. If his actions don't fit neatly into one of these three specific boxes, under the strict letter of the law, it's not concubinage. Moving right along to Section 2, lasciviousness and seduction, intent and deceit. This brings us to a super fascinating boundary in criminal law. Did you know that the exact same physical action can be classified as two completely different crimes? It all depends entirely on what was going on inside the offender's head. Acts of lasciviousness requires clear, lewd designs and lustful intent. But unjust vexation happens when someone commits the act out of sudden passion, anger, or just to spite the victim without that specific lewd motivation. Real jurisprudence shows us how the physical environment actually dictates this legal intent. It's wild. Take the case of People versus Unwavo. A man forcibly embraced and kissed a woman inside a brightly lit Catholic church. The court ruled this was merely unjust vexation. Their reasoning? The public, well-lit religious setting made lewd design highly unlikely. He was just doing it to vex or spite her. But in U.S. versus Gomez, a very similar act happened inside a darkened theater. Because of the secretive, dark environment, the court ruled there was clear lewd design, making it acts of lasciviousness. The setting literally changed the crime. Now, let's look at seduction. Qualified seduction isn't just about some deceitful promise of marriage. When the victim is a minor, specifically 16 to under 18, and the offender is someone like a teacher, guardian, priest, or a domestic worker living in the same house, the law elevates the crime to qualified seduction. The law heavily penalizes those who use their position to exploit the vulnerable. It's seen as a severe breach of trust. Up next is Section 3, defining sexual harassment, transactional versus gender-based spaces. Let's take a look at how the law has evolved over time. The older framework, Republic Act 7877, relies really heavily on a transactional power dynamic. It requires the offender to have moral ascendancy, think like a boss or a professor, demanding a sexual favor in exchange for a promotion or maybe a passing grade. But as we know, harassment isn't always transactional. So the newer Safe Spaces Act steps in to penalize gender-based hostility in any environment, completely regardless of whether a favor is demanded or who actually holds the authority. Under the Safe Spaces Act, the legal definition of harassment expands massively. It's a real game changer. It now explicitly criminalizes street harassment, stuff like catcalling, wolf whistling, intrusive gazing, and using sexist or transphobic slurs. It even extends into the digital realm to cover online sexual harassment. And crucially, it actually penalizes employers or school heads who fail to take immediate action on reported acts. Moving into Section 4, child exploitation and trafficking, severe penalties for protecting the vulnerable. There is a vital distinction in how the law treats victims versus businesses here. The older white slave trade law punishes the business of prostitution generally, profiting from a house of ill repute, regardless of the age of the women involved. However, Republic Act 7610 strictly treats child prostitutes as victims, not offenders. The law ruthlessly penalizes anyone facilitating their exploitation, from the procurers all the way up to those managing the establishments. So the absolutely crucial point here is this number, 12. Under the law, if a victim of exploitation, sexual abuse, or abduction is under 12 years old, they are considered entirely incapable of giving consent, period. There is no such thing as a consented crime if the victim is under 12. The presence of force or intimidation is legally presumed, which automatically elevates the crime and the penalty significantly, usually to statutory rape or forcible abduction in every single case. To protect these incredibly vulnerable minors, anti-trafficking laws are rightfully unbelievably strict. Just attempting to traffic a child is heavily penalized long before any actual harm or transportation even occurs. Acts like making a child travel abroad without proper clearance, a doctor faking a birth record, or a pregnant mother signing an adoption consent form in exchange for money, all of these are aggressively prosecuted as attempted child trafficking. All right, our final section, Section 5, the laws on abduction, forcible versus consented. Once again, we see how a single missing element alters the crime completely. Forcible abduction is the taking of any woman, regardless of her age or reputation, against her will, provided there are lewd designs. But if the woman goes willingly, it's no longer forcible. It only becomes consented abduction if the victim meets some very strict criteria. She must be a minor, over 12 and under 18. She must be a virgin. She must have been persuaded through cajolery or deceit. And of course, there must still be lewd designs. This brilliantly illustrates how the law thinks. You see the word virgin in the statute for consented abduction, but jurisprudence clarifies that legal virginity is not just a biological fact. It actually refers to a virtuous woman of good reputation. So even if she had prior relations, if her reputation in the community is good, the law still steps in to protect her from being tricked and taken away. Let's test what we've learned with a quick question. Can a husband be liable for the forcible abduction of his own wife? Well, based on the case of People versus Omar, the answer is no. Even if he takes her entirely against her will, the essential element of lewd design is legally wanting, meaning it's absent between a married couple. Without that lewd design, the taking might be grave coercion or maybe kidnapping, but technically speaking, it is not forcible abduction. Before we wrap up, it's absolutely vital to note the strict procedural rules governing these private crimes. Even if the police witness the act firsthand, and even if all the elements of adultery or concubinage are met perfectly, the state cannot simply prosecute the offenders on its own. Nope. The law actually mandates that the case cannot proceed without a sworn complaint directly signed and filed by the offended spouse. The power to initiate justice here rests entirely in their hands. Which brings us to our final thought. Today, we've seen how a single missing element, a lit room instead of a dark theater, the exact age of a victim, the presence of lewd design, or even just a simple signature, can be the entire difference between a severe conviction and a complete acquittal. It really leaves us to wonder, as our society continues to evolve, do these strict categorical boundaries of the written law always capture the true reality of the offense? Thank you so much for joining me on this explainer, and keep questioning the frameworks that shape our world.
This video covers the topic of adultery under Article 333 of the Revised Penal Code. Adultery is a crime against chastity. The penalty may be mitigated if the abandonment was without justification or due to sheer necessity. Mitigation in adultery can extend to both defendants. Article 62, Paragraph 3 of the Revised Penal Code is not applied because the act is considered a single, juridical act, not a felony by itself. The elements of adultery by a woman include being married. Proof of marriage is required, but it is not necessary that the marriage be valid at the time of the offense. Adultery exists even if the marriage is later declared void. Punishment for adultery is justified, even if the marriage is subsequently declared void. The bond of matrimony is not dissolved until declared null by a competent authority in a final judgment. The offense against vows and family exists until then. In some cases, a subsequent marriage during the lifetime of a first spouse is illegal and void without judicial decree. However, the Family Code now requires a final judgment declaring a previous marriage void for purposes of remarriage. The offended party must be legally married to the offender at the time the criminal case is instituted. The person initiating the prosecution must be the offended spouse, and still married to the accused spouse when filing the complaint. A second element of adultery is that the offender had sexual intercourse with a man, not her husband. Carnal knowledge can be proven by circumstantial evidence, such as love letters, or being surprised together in intimate situations. The standard of evidence for adultery conviction is not sufficient for the application of Article 247 of the Revised Penal Code, which requires surprising the spouse in the act of sexual intercourse. Pardon by the husband for adulterous acts committed after the pardon is not exempting. The elements of adultery by a man include that the offender is a married or unmarried man, had sexual intercourse with a married woman, and knew the woman was married. A man not liable for adultery due to lack of knowledge of the woman's married status may be liable for concubinage. A married woman can be liable for adultery for having sexual intercourse with a married man, or for concubinage if she knew the man was married. The essence of adultery is the violation of the marital vow. The gist of the crime is the danger of introducing spurious errors. Acquittal of one defendant does not automatically acquit the other for various reasons, including joint criminal intent. The death of the offended party does not extinguish criminal liability for adultery. However, if the offended party dies before signing the complaint, the case cannot proceed, because no one can sign and file the complaint. Pardon extinguishes criminal liability only if made before the institution of the criminal prosecution and in favor of both offenders. Sexual intercourse subsequent to adulterous conduct can be considered an implied pardon, but an express pardon does not require sexual intercourse. The effect of consent bars subsequent prosecution for adultery. Agreement to separate, though void in law, explains the husband's inaction, implying consent to the infidelity. Under the law, there can be no accomplice in adultery. Concubinage under Article 334 is less severely punished than adultery. The three ways of committing concubinage are keeping a mistress in the conjugal dwelling, having sexual intercourse under scandalous circumstances, or cohabiting with a woman who is not the offender's wife. The elements of concubinage include that the offender must be a married man, or a woman who knows him to be married. The woman's knowledge of the man's married status must be acquired before the crime's commission. The man is liable for concubinage only for the acts specified in the Revised Penal Code. The offense is committed if the offender commits any of the acts specified in the Revised Penal Code. This includes keeping a mistress in the conjugal dwelling, even without proof of sexual intercourse, especially when circumstantial evidence, such as pregnancy, exists. Concubinage by keeping a mistress in the conjugal dwelling does not require proof of scandalous circumstances. A mistress is defined as a woman voluntarily taken into the house and sheltered, but not as a child or ward, and who is taken into the dwelling as a concubine. The conjugal dwelling is the home of the husband and wife, even if the wife is temporarily absent. A house built from conjugal properties, especially if intended as such, is a conjugal dwelling, even if the wife never resided there. Concubinage also involves having sexual intercourse under scandalous circumstances outside the conjugal dwelling. Scandalous circumstances means a reprehensible word or deed that offends public conscience and is detrimental to honest persons. Proof of scandalous circumstances can include the accused and mistress living in the same room, appearing together in public, or performing acts that lead to criticism and general protest among neighbors. People in the vicinity are considered the best witnesses to prove scandalous circumstances. No evidence of scandalous circumstances exists if only spies are employed to watch the conduct of the accused. The third way to commit concubinage is cohabiting with a woman not the man's wife in any other place. Mere cohabitation is sufficient, and proof of scandalous circumstances or actual sexual intercourse is not necessary. Cohabitation means dwelling together as husband and wife, distinguished from occasional, transient interviews for unlawful intercourse. Being surprised in the act of sexual intercourse in a hotel or furnishing an apartment without sleeping there is not concubinage. Being the father of a child with a woman not his wife by itself does not constitute concubinage. Concubinage is a violation of the marital vow, but unlike adultery, it does not necessarily bring spurious offspring into the family. This section covers Article 335 on the repealed law on rape, focusing on when and how rape is committed under Republic Act No. 8353 and the effect of marriage between the offender and offended party. We begin with acts of lasciviousness under Article 336 of the Revised Penal Code, looking at the penalties and elements. One element is the offender committing an act of lasciviousness or lewdness. with an example being compelling a girl to dance naked, even if the dominant motive was revenge. Embracing, kissing, and holding a girl's breast is considered an act of lasciviousness. However, in certain cases, touching a girl's breast has been considered merely unjust vexation if there was no admixture of lewd designs, such as in situations of religious atmosphere or public view during wooing. Lovers' embraces and kisses are not considered acts of lasciviousness if there is no evidence of lustful design. Another act of lasciviousness is the placement of the offender's private parts over the victim's private part, even without penetration. An act of lasciviousness must also be done under circumstances enumerated in the Revised Penal Code, now referencing Article 266A. These circumstances include using force, threat, or intimidation if the woman is deprived of reason, or is under 12 years of age or demented, or by fraudulent machination or grave abuse of authority. The offended party can be of either sex. Presently, rape is committed under specific circumstances mentioned in the Revised Penal Code, as amended. It is important to note the specific provisions related to the age of the offended party, particularly the exception when the age difference is small and the act is consensual, non-abusive, and non-exploitative. Acts of lasciviousness must be distinguished from grave coercion. The motive for lascivious acts is not always important, as the essence of lewdness is often found in the act itself, especially when force is used against the victim's chastity. The presence or absence of lewd designs in acts of lasciviousness is inferred from the nature of the act and the environmental circumstances. However, the rule differs if the act is committed in a dark environment, like a theater, where intent of lasciviousness is more readily presumed. There is no inflexible rule to determine lascivious intent. It is determined by overt acts. Acts of lasciviousness are also distinguished from attempted rape. If the acts done indicate a purpose for intercourse, the crime is attempted rape. It is not attempted rape where there is no intent for sexual intercourse, even if opportunities arise. Conversely, specific circumstances such as removing clothing and persistent fondling with force strongly indicate intent to commit intercourse, qualifying the act as attempted rape. Desistance in the commission of attempted rape may constitute acts of lasciviousness, but does not imply absolute irresponsibility for acts already committed. Acts of lasciviousness admit only of one stage of execution, consummated, as the offender achieves their purpose immediately upon performance of the act. Acts of lasciviousness are further distinguished from unjust vexation. Unjust vexation involves kissing or embracing without lewd design, arising from passion or other motives. However, touching private parts, especially if the victim is under 12 years old or incapacitated, constitutes an act of lasciviousness. We move on to Chapter 3, which covers seduction, corruption of minors, and white slave trade. Note the distinction between acts of lasciviousness and unjust vexation remains relevant when determining intent. Qualified seduction, under Article 337, involves enticing a woman to unlawful sexual intercourse by promise of marriage or other means of persuasion without force. The definition of seduction now describes the victim as a minor 16 years or over but under 18 years of age, as amended by Republic Act No. 11,648. The penalty for qualified seduction varies based on the circumstances. It is lighter, where there is only an abuse of authority or confidence, but higher by 1 degree, where there is an abusive relationship. There are two classes of qualified seduction. First, the seduction of a minor, 16 and over but under 18 years of age, by persons such as a public authority, priest, or teacher. Second, the seduction of a sister by her brother, or a descendant by an ascendant, regardless of age or reputation. The elements of qualified seduction include the offended party being a minor. Previously, she had to be a virgin of good reputation. If the woman is married and the offender knows it, the crime is adultery, not seduction. Marriage prevents seduction, even if the victim is the seducer's sister or descendant. Mere married status does not negate virginity for qualified seduction. Importantly, it is enough that the victim is a minor. Previous rulings required the victim to be a virgin, but subsequent rulings focused more on the chaste character being open to question in certain cases. The victim must be 16 years or over, but under 18 years of age. If the victim is under 16, the crime is rape, not seduction. If the victim is over 18, qualified seduction is not committed unless she is the offender's sister or descendant. Lastly, the offender must have sexual intercourse with her, otherwise it may be consented acts of lasciviousness. there must be an abuse of authority, confidence, or relationship by the offender. Examples of abuse of authority include a person in public authority or a guardian. Abuse of authority also includes teachers or any person entrusted with the education or custody of the woman seduced, such as a master having sexual intercourse with a female servant. Abuse of confidence applies to a priest or a house servant, for instance, a house servant having sexual intercourse with a master's daughter. Domestic also refers to a person living under the same roof. However, a traveling man merely stopping at a public tavern or inn is generally not considered a domestic. Abuse of relationship, often considered incest, applies when a brother seduces his sister. While technically not incest, a brother-in-law may also be found guilty of qualified seduction due to moral ascendancy. Abuse of relationship also includes an ascendant who seduces their descendant. Deceit is not an element of qualified seduction, as abuse of confidence implies deceit. Importantly, consent is no defense in seduction. Qualified seduction is distinguished from rape. Seduction involves consented sexual intercourse, while rape involves force, threat, intimidation, fraud, or grave abuse of authority, or when the victim is under 16. An accused charged with rape involving a deadly weapon or violence cannot be convicted of qualified seduction under the same information. Finally, incest is distinguished from incestuous rape based on the elements and circumstances of the offense. Title 11 of the Revised Penal Code covers crimes against chastity, specifically in Chapter 3, seduction, corruption of minors, and white slave trade. Simple seduction, under Art 338, is punished not for illicit intercourse, but for destroying the chastity of unmarried women of previous chaste character through a promise of marriage, which is then unfulfilled. The third element of simple seduction states that the offended party must be a minor, specifically 16 and over but under 18 years of age. If the party is under 16, the crime is rape. If over 18, and none of the circumstances in Art 335 are present, no crime is committed even with sexual intercourse. The offender must have had sexual intercourse with the offended party. The offended party must be a minor and is no longer required to be of good repute, differentiating it from earlier provisions and qualified seduction, which required the victim to be a virgin. Previously, the woman needed to be of good reputation. Under the present provision, this is no longer required. Even a woman previously raped may be a victim of simple seduction, as the requirement for good reputation is now also removed. The sexual intercourse must be committed by means of deceit, which often takes the form of an unfulfilled promise to marry, relied upon by the woman. However, a promise of marriage made after the sexual intercourse does not constitute deceit. A promise of marriage made by a married man, known to be so by the woman, is not considered deceit. Also, a mere manifestation of willingness to marry before or after the crime is not a defense, but can amount to deceit depending on attending circumstances. An unfulfilled promise of material things does not constitute the deceit required for simple seduction. Furthermore, seduction is not a continuing offense. Carnal relations after the woman turns 18 are not a continuation of the offense begun when she was a minor. Acts of lasciviousness with consent of the offended party, Art 339, carry a specific penalty. The elements include the offender committing acts of lasciviousness or lewdness. These acts are committed upon a minor 16 years or over but under 18 years old, or a sister or descendant regardless of reputation or age. The offender must accomplish the acts by abuse of authority, confidence, relationship, or deceit. Previously, a male person could not be an offended party, but the current law simply describes the victim as a minor 16 to under 18 years old. This offense is different from acts of lasciviousness under Art 336. Republic Act No. 7877 declares all forms of sexual harassment in employment, education, or training environments as unlawful. The penalty includes imprisonment and/or a fine. The elements of work, education, or training-related sexual harassment are listed, starting with the offender being enumerated in Section 3 of RA 7877, such as an employer or employee. The list of potential offenders under RA 7877 continues to include a manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person with authority, influence, or moral ascendancy over another in the specified environment. A second element of sexual harassment under RA 7877 is that the offender demands, requests, or otherwise requires sexual favor from the offended party. It is immaterial whether the demand, request, or requirement for submission is accepted by the object of said act. The elements of work-related sexual harassment in the employment environment include the offender being an authority figure or person with influence. The offense is committed when a sexual favor is made a condition in hiring, employment, re-employment, or continued employment. The act of sexual harassment also includes making a sexual favor a condition for granting favorable compensation, terms, conditions, promotions, or privileges. It also covers limiting, segregating, or classifying the offended employee as a result of refusal to grant sexual favor, thereby creating a hostile environment. For sexual harassment in the education or training environment, the offender is typically a teacher, instructor, professor, coach, trainer, or person with moral ascendancy. The offender's act is committed against specified victims, such as one under the care, custody, or supervision of the offender, or whose education or tutorship is entrusted to the offender. The offender commits sexual harassment by making a sexual favor a condition for giving a passing grade, or the granting of honors and scholarships, or the payment of stipends or other benefits. It also includes making sexual advances that result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. Criminal liability for sexual harassment under Section 3 of RA 7877 can be incurred in three modes. First, by a person directly committing the act. Second, by a person directing or inducing another to commit the act. Third, by a person cooperating in the commission of the act, without which it would not have been committed. Representative Act No. 7877 allows for a separate civil action for damages based on acts of sexual harassment in the work or educational environment. Furthermore, an employer, head of office, educational, or training institution can be held solidarily liable for damages with the offender if they were informed of the sexual harassment and took no immediate action. Acts of sexual harassment under RA 7877 must be distinguished from crimes against chastity under the Revised Penal Code. Sexual intercourse or acts of lasciviousness are not elements of sexual harassment, which focuses on the demand, request, or requirement of sexual favor, regardless of acceptance. Republic Act No. 11313 defines and penalizes gender-based sexual harassment, distinguishing it from the transactional type covered by RA 7877. This includes gender-based sexual harassment in streets and public spaces, encompassing acts like catcalling, leering, and unwanted invitations, among others. Other acts of gender-based sexual harassment in public spaces include offensive body gestures and exposure of private parts to demean or intimidate the offended party, such as groping. Stalking, or similar acts accompanied by touching or brushing against the victim's body, is also penalized, as is gender-based online sexual harassment. Qualified gender-based sexual harassment carries a higher penalty. The Safe Spaces Act also addresses gender-based sexual harassment in the workplace and educational institutions. Penalties are set for employers or school heads who fail to implement duties, including administrative penalties for violations, or fail to take action on reported acts. Corruption of minors under Art 340 of the Revised Penal Code has specific elements. The offender must promote or facilitate the prostitution or corruption of another, and that person must be a minor, now defined as below 18 years of age. Historically, the victim was also required to be of good reputation. The corruption of minors must be accomplished to satisfy the lust of another. It's important to note that the unchaste acts themselves do not need to be performed. The act of promoting or facilitating the corruption of the minor is what is penalized under Art 340. Habituality or abuse of authority is no longer a necessary element for the crime of corruption of minors, following the amendment by Batas Pambansa BLG 92. This means a single act of facilitation in the corruption of a minor can be penalized under Art 340 of the Revised Penal Code. Republic Act No. 7610 severely penalizes child prostitution, other sexual abuse, and child trafficking. Child prostitutes are considered victims under this law and are deemed children exploited in prostitution. Punishable acts include engaging in, promoting, facilitating, or inducing child prostitution. The acts punished under RA 7610 include acting as a procurer, inducing clients through advertisements, taking advantage of influence or relationship to procure a child as a prostitute, and using threats or violence to engage a child in prostitution. Giving monetary or other pecuniary benefits to a child with the intent to engage them in prostitution is also penalized. Child prostitution under RA 7610 is distinguished from white slavery in the Revised Penal Code, as RA 7610 focuses on minors, who are considered victims. Committing sexual intercourse or lascivious conduct with a child exploited in prostitution or subjected to other sexual abuse is penalized. If the victim is under 16 years of age, the accused should be prosecuted for rape or acts of lasciviousness, with increased penalties under RA number 11648. RA 7610 also punishes deriving profit or advantage from child prostitution or sexual abuse. This applies to owners or managers of establishments where prostitution takes place, including those serving as covers for such activities. The attempt to commit child prostitution is also penalized under RA 7610. This includes being found alone with a child in specified places, where a reasonable person would believe the child is about to be sexually exploited, or receiving services from a child in specified establishments. Child trafficking, defined as trading or dealing with children for money or other considerations, is severely penalized under RA 7610. The penalty is reclusion temporal to reclusion perpetua, with the maximum period applied if the victim is below 16 years of age, as amended by RA number 11648. This must be distinguished from slavery under the Revised Penal Code. Attempt to commit child trafficking is also penalized. This includes specific acts, such as making a child travel alone to a foreign country without valid reason or clearance from the Department of Social Welfare and Development, or without parental permission. Other acts constituting attempted child trafficking include executing an affidavit of consent for adoption for a consideration, recruiting women or couples to bear children for the purpose of child trafficking, and simulating birth for trafficking purposes. White slave trade under Art 341 of the Revised Penal Code penalizes engaging in the business of prostitution or profiting by prostitution. The commission of just one of the acts mentioned in Art 341 is sufficient to constitute the offense. Enlisting the services of women for prostitution is also covered, and sharing in the income of prostitutes is sufficient proof of profiting. Habituality is not a necessary element, as it is sufficient if the accused commits any of the enumerated acts. Maintaining a house of ill repute is considered engaging in the business of prostitution. The person responsible is the maintainer or manager, and they do not need to be the owner of the house or present at the time of raid or arrest. The video will now discuss the distinction between white slavery and prostitution. This video covers forcible abduction as defined in Article 342 of the Revised Penal Code. Abduction is defined as taking away a woman with the intent to marry or corrupt her, violating individual liberty, honor, and public order. Forcible abduction has several key elements. First, there must be an abduction. Second, the person abducted must be a woman, regardless of her age, civil status, or reputation, similar to the rules for rape. Other crimes against chastity where the victim's age and reputation are immaterial include rape, acts of lasciviousness, and qualified seduction. Forcible abduction, under Article 342, differs from consented abduction, where the victim is a virgin between 12 and 18 years old, according to Article 343. A critical element of forcible abduction is that it must be against the woman's will. For example, in People v. Castillo, the victim was forcibly dragged and taken to another location against her resistance, confirming the element of force in forcible abduction. Taking a woman against her will may begin with deceit and transition to violence. If the victim is under 12 years of age, forcible abduction is committed even if she voluntarily goes with the abductor, as she is deemed incapable of giving consent. Another key element is that the abduction must be with lewd designs. Lewd designs are shown by actions such as kissing, embracing, and attempting to hold the victim's body. However, kissing alone may not be sufficient to demonstrate lewd designs, depending on the context. Lewd designs can also be indicated by a hurried, forced marriage ceremony. However, the intent to marry does not constitute an unchaste design if both parties are of marriageable age and without legal impediment. In cases with multiple offenders, if one has lewd designs and others cooperate, all may be liable for abduction. A husband cannot be held liable for the forcible abduction of his wife as the lewd design element is missing. Sexual intercourse is not necessary for forcible abduction, but if it occurs afterward under certain conditions, it becomes a complex crime of forcible abduction with rape. Forcible abduction is distinguished from grave coercion primarily by the presence of a lewd design. Both involve violence or intimidation to compel the victim against her will. However, grave coercion lacks the element of lewd design. Forcible abduction with rape is distinct from kidnapping. When violent taking is motivated by lewd designs, resulting in brutal ravishment, the crime is forcible abduction with rape. If not so motivated, it is kidnapping or serious illegal detention. There is no complex crime of forcible abduction with attempted rape, as the attempt to rape is absorbed by the abduction, serving as the lewd design element. However, forcible abduction can be distinguished from acts of lasciviousness, which require the lecherous acts to be actually committed. In some cases, the situation may result in rape only or abduction only. If abduction is followed by rape without tenacious resistance, it's considered abduction only. If forcible abduction is carried out with rape as the main objective, it may be rape only. Forcible abduction is also distinguished from corruption of minors. Abduction is characterized by lewd design, while corruption of minors is for the purpose of lending the minor to illicit intercourse. Forcible abduction can remain in the attempted stage if the accused is prevented from successfully taking the victim. Moving to consented abduction, Article 343, Revised Penal Code. The purpose is not to punish the wrong to the victim, as she consented, but to address the disgrace to her family and alarm caused by her disappearance. The first element is that the offended party is taken away. The second element of consented abduction is that the offended party must be a virgin. Virginity is understood as a virtuous woman of good reputation, not strictly in a material sense. The third element is that the offended party must be over 12 and under 18 years of age. If the victim is under 12, it is forcible abduction. The taking away of the offended party must be with her consent, often after solicitation or cajolery. Even if there was no physical taking, and the victim left voluntarily by prearrangement, consented abduction can still exist, provided the accused was instrumental in her escape. In consented abduction, the taking away of the victim need not be permanent. The crime exists no matter how short the taking away is. This departs from earlier Supreme Court decisions that required a character of permanency or an appreciable period of time. Consented abduction may be induced by a honeyed promise of marriage. However, if there was no solicitation, cajolery, or deceit, and the girl voluntarily went with the man, no consented abduction is committed, even if sexual intercourse occurred. The taking away of the offended party must be with lewd designs. The intentions of the accused must be unchaste and lewd. Consented abduction with rape is a complex crime, as seen in a case where a minor girl, induced to leave home, was forcibly violated. We now discuss the prosecution of crimes against chastity, excluding rape. The rules for prosecuting adultery, concubinage, seduction, abduction, and acts of lasciviousness require the aggrieved party to file a proper complaint. Adultery and concubinage must be prosecuted upon a complaint signed by the offended spouse. The absence of a signature by the offended party is a fatal defect that silence or acquiescence by the accused cannot cure. Additionally, prosecution for adultery or concubinage requires including both guilty parties and is barred if the offended party consented or pardoned the offenders. Pardon in crimes against chastity, excluding rape, can be either implied or express. In adultery or concubinage, pardon need not be express. However, condonation, which is forgiveness based on repentance, does not bar prosecution for subsequent acts. Delay in filing a complaint, if sufficiently explained, does not indicate pardon. Forgiveness does not constitute tolerance or acquiescence if the delay is used for accumulating evidence while the accused are cohabiting. Pardon in seduction, abduction, or acts of lasciviousness must be express. Furthermore, pardon for adultery and concubinage, as well as seduction, must occur before the institution of criminal action. Pardon for acts of lasciviousness must also precede the criminal action. However, the marriage of the offender and the offended party during the case extinguishes the criminal action or remits any penalty already imposed. In adultery or concubinage, both offenders must be pardoned for it to be effective. Also, parents of the offended party cannot grant a pardon for adultery or concubinage, as the law requires the pardon to come from the offended party. In seduction, abduction, or acts of lasciviousness, parents, grandparents, or guardians can only pardon if the offended party is dead or incapacitated. This pardon may also require the express pardon of the offended party herself. For cases where the offended party is a minor, the pardon must have the concurrence of the parents. However, if the minor has no parents to concur, a pardon by the minor alone may be sufficient. We continue to discuss Title 11, which covers crimes against chastity and provisions relating to preceding chapters. It details the prosecution of crimes like adultery, concubinage, seduction, and abduction, noting the modification of rape to a crime against persons by Republic Act No. 8353. Consent in adultery or concubinage bars prosecution. Subsequent consent is as effective as prior consent. However, a mere agreement to cease the spousal relationship for good is not consent to adultery or concubinage. An affidavit of the offended party showing consent, filed during the pendency of an appeal, can be a cause for remand for a new trial. However, if an affidavit of desistance amounts to a recantation of earlier testimony, a court may deny a new trial if unsatisfied that the testimony is true. An affidavit of desistance showing loss of interest, filed years after the crime and during the pendency of the case, is not an effective pardon, especially if granted only after the institution of criminal action. Separation agreements after knowledge of an adulterous act is considered a pardon. In seduction, abduction, or acts of lasciviousness, consent of the victim is immaterial in cases of qualified seduction or simple seduction, where consent is vitiated by deceit. Consent is immaterial in non-consensual acts of lasciviousness when the victim is below 12 years old, deprived of reason, or otherwise demented. Consent is also immaterial in consented acts of lasciviousness if obtained through abuse of authority, confidence, relationship, or deceit. Consent by a victim below 12 years old is immaterial in forcible abduction. Consent in consented abduction is immaterial if obtained by solicitation or cajolery, as the crime presupposes vitiated consent. Seduction, abduction, and acts of lasciviousness must be prosecuted upon a complaint by specified persons in a named order. The offended party is preferred over all others. For a minor offended party, minority is not an obstacle to prosecution of private offenses. Parents, grandparents, or guardians may prosecute in that order if the minor does not file a complaint and is not incompetent or incapacitated on other grounds. If the offended party is of age and in complete possession of mental and physical faculties, the right to prosecute is exclusive to them, excluding parents and other relatives. A woman attains the age of majority at 18. Parents may file a complaint if the offended party is a minor and does not file one themselves. No preference is established between the father and mother in filing a complaint for seduction. Grandparents and legally appointed guardians may also file complaints. A complaint must be filed with the court and signed by the offended party for the court to acquire jurisdiction. The prosecution of prostitution against a woman, even if married, can be pursued officio due to the crime against public morals. The marriage of the offender with the offended party extinguishes criminal action and remits the penalty for seduction, abduction, and acts of lasciviousness. This benefit extends to accomplices and accessories. The marriage must be entered into in good faith with the intent to fulfill marital duties. Actual marriage, not just the desire to marry, extinguishes criminal liability. Marriage in cases of adultery or concubinage is not included in this rule. Marriage in other crimes does not extinguish criminal liability. The underlying principle for these rules is to protect the offended woman and her family from the scandal of a public trial. We now discuss the civil liability of persons guilty of crimes against chastity under Article 345 of the Revised Penal Code. In rape involving a married woman, only indemnity is allowed, excluding support and acknowledgement of offspring. This is based on jurisprudence preventing the acknowledgement of offspring where the woman is married. If the offended woman is unmarried, support should be allowed, even if the offender is married, as parents have a duty to support even illegitimate children. Acknowledgement of offspring is also allowed, unless prohibited by law, but courts cannot speculate on the possibility of offspring without evidence. When appropriate, the judgment must find that the offspring is a natural child, requiring a finding in the criminal action. Even if the child is not natural or is illegitimate, the judgment should declare the accused as the father, entitled to support and successional rights. Support of offspring is required in every case. In multiple rape cases, all accused must support the offspring, as any of them could be the father. However, recognition of the offspring is not required from multiple offenders due to the impossibility of ascertaining paternity. In adultery or concubinage, civil liability only allows for indemnity for damages. Acknowledgement of offspring is not legally possible because children born of parents who could not marry at conception cannot be recognized. Support of offspring is also excluded. There is no civil liability specifically for acts of lasciviousness under the Revised Penal Code. However, Article 2219 of the new Civil Code provides a basis for moral damages in crimes against chastity. This right is granted to the offended party and their parents. Liability of ascendants, guardians, teachers, or other persons entrusted with custody under Article 346 of the Revised Penal Code applies to seduction and abduction. These individuals are punished as principals if they cooperate as accomplices through abuse of authority or confidential relationship. The crimes covered by this provision include acts of lasciviousness, qualified and simple seduction, corruption of minors, white slave trade, and forcible and consented abduction. The article should exclude references to rape. Welcome to this video on crimes against chastity and honor, the legal architecture. We will synthesize Title 11 of the Revised Penal Code and related special penal laws, including RA 7877, RA 11313, and RA 7610. Our legal architecture rests on 4 pillars of legal protection. Pillar 1 protects the family and marriage against crimes like adultery and concubinage. Pillar 2 safeguards bodily autonomy and honor against acts of lasciviousness and abduction. Pillar 3 ensures trust and safe spaces through laws on seduction and sexual harassment. Finally, Pillar 4 focuses on protecting the youth from corruption of minors and trafficking. Within the marital matrix, adultery and concubinage show asymmetry in the RPC. Adultery, committed by a married woman, is a single act of sexual intercourse, posing a risk of introducing spurious heirs. Concubinage, by a married man, requires either keeping a mistress in the conjugal dwelling, sexual intercourse under scandalous circumstances, or cohabiting elsewhere. The gist is a violation of the marital vow. Jurisprudential nuances clarify marital betrayal. Abandonment by a husband is only mitigating, not exempting, for a wife's infidelity. Regarding concubinage, defining scandalous circumstances requires reprehensible acts that offend public conscience. Private investigations alone do not constitute public scandal. Bodily autonomy, specifically acts of lasciviousness under Art 336, requires a lewd design, or animus lasciviens, proven by overt acts. It must also parallel one of the circumstances of rape, such as force, threat, or the victim being deprived of reason. The act is applicable to victims of either sex and must reach a consummated stage. Distinguishing the acts involves mapping the boundary between unjust vexation, acts of lasciviousness, and attempted rape. The intent differs. Vexation aims to annoy, lasciviousness seeks lust/lewdness as a final objective, and attempted rape intends to copulate. Desistance from copulation can prove an act was merely lascivious. Abduction addresses the deprivation of liberty and honor. Forcible abduction, Art 342, is against the woman's will, driven by lewd designs, and applies to a woman of any age. Consented abduction, Art 343, involves consent extracted through deceit. The victim must be over 12 and under 18, and a virgin of good reputation. The spectrum of seduction, Arts 337 to 338, targets minors who are 16 or over but under 18. Simple seduction is committed through deceit, often an unfulfilled promise of marriage. Qualified seduction is accomplished through abuse of authority, confidence, or relationship, involving specific offenders like public authorities or teachers. Modern protections against sexual harassment have 2 faces. RA 7877 is transactional and authority-based, requiring a demand for a sexual favor in a work or educational environment. RA 11313, the Safe Spaces Act, is gender-based and covers various environments, including public spaces. It does not require a demand for a sexual favor, covering acts like catcalling and sexist slurs. Protecting the youth involves laws against exploitation and trafficking of vulnerable minors, those under 18. Corruption of minors. Art 340 promotes or facilitates a minor's corruption to satisfy another's lust. Child trafficking and child prostitution are also addressed under RA 7610, with severe penalties for offenders and clients. The business of exploitation, white slave trade, Art 341, contemplates victims of any age. The scope includes engaging in the business, profiting financially from prostitution, or enlisting services. Habituality is not required. Committing any single act is sufficient. Procedural shields, rules of prosecution, Art 344, dictate that crimes against chastity require a sworn complaint filed in court to protect the victim. The right to file belongs primarily to the offended party, followed by parents, grandparents, and finally, the guardian, if necessary. An exception exists for prostitution imputations, which can be prosecuted de officio. The power of pardon, consent, and marriage impacts criminal liability. For adultery and concubinage, pardon must occur before the institution of the action and explicitly cover both offenders. Marriage of the offenders is not a defense. For seduction, abduction, and acts of lasciviousness, a valid good faith marriage between the offender and the offended party extinguishes the criminal action, benefiting all involved co-principals and accessories. Civil liability and remediation, Art 345, establish 3 pillars of accountability. Pillar 1 requires indemnification for moral damages. Pillar 2 concerns acknowledgement of offspring, which is required unless the law prevents it, such as when the offended woman is married. Pillar 3 mandates support of offspring in every case, with multiple perpetrators held jointly responsible. In concluding synthesis, we see the evolution of protection. The traditional view focused on chastity and honor, using the RPC as a shield for family reputation. The modern imperative focuses on autonomy and safe spaces, using special penal laws to actively defend individual bodily autonomy, safeguard minors, and eradicate gender-based harassment. Philippine criminal law has evolved to actively defend individual bodily autonomy and systemic safe spaces.
Welcome to This Explainer. You know, when relationships break down, we usually just think of it as a huge emotional mess. But legally speaking, it's a rigid machine. Today, we're going to objectively examine the intricate and, honestly, sometimes surprising mechanics of the penal code regarding infidelity. We're going to unpack the legal syllabus to understand exactly how the law views, defines, and prosecutes a breach of marital vows.
So let me ask you this. If you assume the law treats a cheating husband and a cheating wife exactly the same, well, you are in for a serious surprise. The legal texts reveal a wildly different reality. The penal code draws a very sharp and historically controversial line between the infidelity of a wife and the infidelity of a husband. To make sense of all this, here is our quick agenda. First, we'll define adultery. Second, we'll define concubinage. Third, we'll compare the 2 crimes. And finally, we'll look at the rules of prosecution. Let's dive right in. Section 1, Defining Adultery. Let's see how the law explicitly outlines this first crime. Okay, here's the absolute core of it. Under this specific article of the Penal Code, adultery fundamentally requires the female offender to be married. And the male paramour? Well, he can be single or he can be married. But his criminal liability hinges entirely on one specific thing. Did he know the woman was married when they had relations? Now, you might be wondering, do prosecutors need catching in the act, smoking gun proof to get a conviction? Actually, no. Courts rely heavily on circumstantial evidence. Take the famous case of U.S. versus Legaspi. In that instance, just having love letters, being seen together in various places, and being surprised in a known assignation house, that was absolutely sufficient to convict both parties. This next part is fascinating. The law actually views adultery as an instantaneous crime. In the ruling from People versus Zapata, the court established that adultery is consummated and totally complete at the exact moment of carnal union. This means it is not a continuing offense. Every single individual act of sexual intercourse constitutes a separate, distinct crime of adultery. So why exactly was the law written this way historically? Well, in U.S. v. Mata, the Supreme Court laid out the core rationale. It was all about preventing the danger of introducing spurious heirs into the family bloodline. Historically, the law aimed to ensure a husband wouldn't be forced to financially maintain a child that wasn't his own, and that the inheritance rights of legitimate heirs wouldn't be impaired. All right, moving right along to Section 2, Defining Concubinage. Let's see how the framework shifts completely for married men. Unlike adultery, a married man is not automatically liable under the Penal Code for simply having a single act of sexual relations outside his marriage. To be guilty of concubinage, he actually has to commit one of 3 very specific, sustained acts. It's just a completely different legal threshold. Let's unpack these strict criteria. Notice that simply fathering a child with another woman isn't enough to constitute concubinage on its own. That was clearly established in People versus Benlot. The prosecution actually has to prove the husband kept a mistress right in the family home, or that his outside relations were openly scandalous, or that he literally cohabitated, meaning they dwelt together as husband and wife with another woman somewhere else.
These many narratives from actual case law show how strictly courts interpret these rules. Take People versus Bacon, for example. After a wife left due to marital troubles, the husband brought another woman in. A shared bed and a resulting pregnancy were enough to prove she was kept as a mistress in the home. And then look at People versus Cordova. Even if a wife has literally never stepped foot in a house, if it was built using conjugal funds, the law absolutely considers it a conjugal dwelling.
Okay, this is where the burden of proof gets truly wild. The act has to be so public that it offends the innate sense of morality of the neighborhood. In a fascinating case, U.S. versus Campos Rueda, the offended wife actually hired spies to watch her husband. But because the neighbors hadn't observed any suspicious conduct themselves, the court ruled there was no scandal. Think about that. If the public is blissfully unaware, legally there's no concubinage.
Section 3, comparing the crimes. Let's put both of these legal definitions directly onto the scales. When we put them side by side, the contrast is absolutely stark. You've got an instantaneous act on one side versus sustained, very specific conditions on the other, resulting in vastly different penalties. For adultery, a single act triggers the crime, and the penalty is more severe. For concubinage, a single act is just not enough, and the penalty prescribed by law is considerably less severe. From a strictly legal standpoint, the syllabus explicitly grounds this massive disparity in that historical fear we talked about earlier, the risk of introducing spurious blood into the family line. Concubinage, while still obviously a violation of the marital vow, doesn't run the risk of bringing an outside child into the husband's name to receive his support, and that is exactly what the law uses to justify the lesser penalty. Section 4, Rules of Prosecution. Let's look at how these rigid rules actually play out in a courtroom. This brings us to a super rigid timeline. The state won't just step in automatically to prosecute these crimes. The law absolutely mandates that the offended spouse must be the one to sign the complaint. And, importantly, you cannot selectively prosecute. You can't press charges against your spouse but forgive their paramour or mistress. It's a package deal. The law requires both guilty parties to be formally charged together if they are both alive. Now, the law has a pretty wild view on consent and pardon. Consider the case of People versus Sensano. A husband knew his wife resumed living with her co-accused, did nothing to assert his rights, and literally left for Hawaii for 7 years. The court ruled his total inaction over those years constituted consent, which legally barred him from pressing charges later. But keep in mind, as established in People versus DePata, a pardon only covers the past acts you knew about. It absolutely does not give a free pass for future infidelity. And get this. Even death doesn't entirely stop the scales of justice here. If the offended spouse manages to formally sign and file the complaint, but then passes away, the case keeps going. As the court noted in People versus Diego, the Penal Code seeks to protect the honor and reputation not just of the living, but of the dead as well. The criminal liability of the accused isn't magically extinguished just because the offended party died after filing. As we wrap up this explainer on the Penal Code's framework for adultery and concubinage, we've seen a legal system built on incredibly rigid definitions, historical rationales of bloodlines, and super strict procedural rules. It leaves us with a really compelling final thought to consider. How effectively can the rigid, mechanical machinery of criminal law ever truly capture and regulate the deeply intimate, messy, and complex reality of human relationships? Thank you so much for joining us, and keep exploring.
All right, welcome to this explainer. Today, we're doing a deep dive into the incredibly precise, almost surgical distinctions found in Philippine criminal law. We're going to look at how a tiny, seemingly minor detail, like a specific job title or a broken promise, can literally transform a crime and completely change its penalty.
So think about it for a second. How exactly does the law protect the most vulnerable among us? Well, as you'll see, it's not just about stopping brute physical force. We're going to explore exactly how the justice system draws a hard, definitive line against insidious psychological manipulation and the abuse of trust.
Here's our roadmap for today. First, we'll look at the fine lines of law.
Then we'll compare qualified versus simple seduction. Third, we've got 2 acts of lasciviousness. Fourth, forcible versus consented abduction. And finally, we'll wrap up with the spirit of the law. Let's get right into it.
Starting with Section 1, qualified versus simple seduction. It's really all about the difference between authority and deceit. Okay, so here's the core of it. Under this specific law, seduction actually doesn't involve physical violence at all. If force is used, or if the victim is under 16, the law treats that as rape. Seduction is strictly about the psychological manipulation of an older minor, specifically someone who is 16 or 17.
And this right here is where the crime splits into 2 very distinct paths. Qualified seduction relies heavily on the offender's position of power over the victim. Simple seduction, on the flip side, relies entirely on fraud, like, say, a fake promise of marriage. Because the power dynamic is so massive in qualified seduction, the courts don't even require proof of explicit deceit to say a crime took place. The power imbalance basically does the manipulating for them.
When you look at the elements side by side, the logic is pretty fascinating. If a guardian abuses their ward, that power imbalance is so strong that it inherently corrupts the minor's consent. The law literally implies the deceit. But for simple seduction, prosecutors have to explicitly prove the exact lie that drew the minor in. And check out the asterisk there. Incestuous relationships are automatically considered qualified seduction, no matter the age. In both of these scenarios, the minor's consent is absolutely never a valid defense.
So who exactly gets charged with qualified seduction? Well, the law drops the hammer on folks who weaponize their moral authority. We're talking about teachers entrusted with a student's education, priests taking a confession, or even live-in domestic staff who shatter the presumed safety of the home.
But that brings up an interesting question, right? What happens if the offender clearly has lewd designs and actively manipulates the victim, but there isn't actually any sexual intercourse?
That brings us perfectly to Section 2. 2 acts of lasciviousness. This is when the act itself is the final objective.
Under the law, this crime is super unique because it's consummated instantly. The exact second the lewd act occurs, boom, the crime is totally complete. There's no attempted or frustrated stage with this one. If the offender's goal was just to commit the lewd act, it lands right here. Now, if the evidence shows they intended to go all the way to intercourse but got stopped, well, then it gets bumped up to attempted rape instead.
The Penal Code draws a line between these lewd acts based on one single thing: consent. Once again, we're looking at that classic battle of force versus fraud. Article 336 deals with physical violence against literally anyone, but Article 339 zeroes in specifically on minors who technically say yes, but that consent is legally totally invalid because it was squeezed out of them through authority or deceit.
You really have to notice the strict legal symmetry going on here. It's like a mirror. The non-consented version flawlessly mirrors the elements of rape, just without the intercourse part. The consented version, it perfectly mirrors seduction, again, without the intercourse. The justice system is perfectly scaling the punishment based on the exact weapon the offender chose to use, whether that was physical force or their undue influence.
Okay, but what if a victim isn't just manipulated or assaulted right where they stand? What if they are physically taken away to a completely different location? Well, that takes us to Section 3. Forcible versus consented abduction. It's all about the element of taking someone away.
Now you have to understand, abduction is distinctly different from kidnapping or coercion. If you violently drag someone off because they owe you money, that's kidnapping. For a crime to be classified as abduction, the law absolutely demands the presence of unchaste, lewd designs or a specific intent to force the victim into a hurried marriage.
But watch what happens to the legal profile of the victim when we introduce that tricky element of consent. Forcible abduction applies to taking literally any woman against her will. But the second the woman actually agrees to run away, the law gets incredibly specific.
For consented abduction to occur, the willing victim has to be a minor between 12 and 18, and crucially, she must be considered a virgin of good reputation. On top of that, she must have been convinced to leave through the offender's active cajolery. That means coaxing, sweet-talking, or solicitation. It's not just a casual suggestion.
There are some absolutely vital exceptions to keep in mind here. First off, anyone under the age of 12 is deemed legally incapable of giving consent, period. So even if they go willingly, it's automatically classified as forcible abduction. Second, and this is a bit surprising to a lot of people, jurisprudence tells us that virginity in this legal context isn't just purely physical, it's heavily tied to having a virtuous reputation in the community.
Finally, if two teenagers are just crazy in love and a minor runs away to her partner's house completely of her own free will without any sweet talking or pressure from the partner, well, consented abduction actually hasn't been committed.
Which brings us to our final part, Section 4, the spirit of the law. Why do these incredibly precise distinctions even matter? Well, the legal system recognizes that exploitation comes in so many different forms. By carefully separating force from fraud, the law is acknowledging a crucial reality. A teacher abusing their moral authority over a student is a profoundly different type of crime than a stranger attacking someone in an alley, even if the tragic end result looks identical.
Take a look at this brilliant quote from the jurisprudence of People versus Iman. It really hits the nail on the head regarding the true spirit of these laws. The law isn't trying to be the morality police here. Instead, it is specifically taking aim at the despicable act of deception. It's punishing the breaking of trust, the calculated abuse of power, and the intentional destruction of a young person's reputation and future.
So, as society's understanding of psychological manipulation and complex power dynamics continues to evolve, we have to ask ourselves, will the strict, traditional boundaries of these laws need to be rewritten? I'm going to leave you with that provocative thought to chew on. Because as our modern definitions of consent change, we really have to consider if these older legal frameworks, rooted in very specific ideas of reputation and rigid age brackets, will continue to serve justice, or if they are destined to evolve with us. Thanks for joining us on this explainer.
Okay, let's dive right into this explainer and really demystify the legal definitions of sexual harassment under Philippine law. Right off the bat, we need to break a very common misconception, the idea that sexual harassment only involves physical touching or acts of violence. The legal reality is actually so much broader than that, and it's deeply tied to power dynamics and the everyday spaces we all occupy. We're drawing directly from the criminal law 2 syllabus to understand exactly how these specific statutes protect you. So here's our roadmap for today. First up, defining transactional harassment. Then we'll look at work and school environments. From there, we dive into the Safe Spaces Act, harassment in public spaces, and finally, institutional accountability. We're basically mapping out how your legal protections evolved chronologically, going from strict hierarchical environments to the everyday public and digital spaces we all navigate.
Section 1. Defining transactional harassment under Republic Act No. 7877. We're starting our timeline back in 1995 with this incredibly foundational law, which is entirely built around the concepts of authority and transactions. The absolute crucial point here is that this original law explicitly targets people who hold power over you. It's about how professional and academic environments can be turned into transactional traps. Under Republic Act 7877, sexual harassment is strictly defined by the presence of authority, influence, or what the law beautifully calls moral ascendancy. The offense actually happens when a person in that specific position demands, requests, or requires a sexual favor. So who exactly holds this moral ascendancy in the eyes of the law? Well, it's a pretty wide range. It could be your manager or supervisor at the office, your professor in a lecture hall, or even your athletic coach on the field. The law specifically names these roles because, let's face it, they possess inherent power over your livelihood, your grades, or your status on a team. Now, here's what's truly fascinating legally. It's something called the gravamen, which is basically just a fancy legal term for the core essence of the offense. While older laws concerning crimes against chastity typically required actual physical acts, Republic Act 7877 doesn't require physical acts at all. The core offense is the mere demand or request of a sexual favor. And get this, legally, it is entirely immaterial whether you accept or reject that demand. The crime is committed the absolute second the request is made by someone in authority.
Moving on to Section 2, work and school environments, and exactly where RA 787 applies. Let's see how this power dynamic can unfortunately weaponize your daily routine. Whether you're hustling to land a promotion at work or just trying to keep your university scholarship, making a sexual favor a condition for any of these opportunities is a direct legal violation. In the workplace, we're talking about hiring, continued employment, promotions, and compensation. In an educational setting, it covers getting a passing grade, granting honors, scholarships, or even the payment of your stipends. If a sexual favor somehow becomes the currency for any of these things, a crime has absolutely been committed. Ultimately, the law recognizes something very important here. Even beyond those conditional favors, if someone's advances create a toxic, intimidating, hostile, or offensive environment in your everyday life, Republic Act 7877 outlines your specific protections. You literally do not have to lose your job or fail your class to be a victim. Just being subjected to a hostile environment by an authority figure is enough to be covered.
But, what happens when the harasser isn't your boss or your teacher or anyone in authority? That brings us to Section 3, the Safe Spaces Act and expanding protections. For years, there was a huge gap in the law when dealing with a peer, a random stranger on the street, or a troll online. Enter the Safe Spaces Act, or Republic Act No. 11313. This was an absolute game changer in Philippine legal protections. It shifts the entire paradigm to penalize gender-based sexual harassment, completely removing the requirement for the offender to be in a position of power. It doesn't matter if they have zero authority over you. This law finally recognizes that harassment is about gender-based disrespect and intrusion, plain and simple. Section 4, harassment in public spaces. Let's look at how this applies out on the streets and on our screens. The Safe Spaces Act is incredibly specific about the everyday behaviors that are now legally actionable. It explicitly protects you against public violations, categorizing acts like wolf whistling, catcalling, and intrusive leering as harassment, using homophobic, transphobic, or sexist slurs, criminal offenses, persistent unwanted comments on someone's appearance, also covered. It even penalizes relentless requests for your personal details, like constantly demanding your number or asking where you live. What used to be entirely dismissed as just boys being boys or street culture is now strictly penalized. And it goes even further to cover aggressive physical space violations, exposing private parts, public masturbation, groping, or any of that unwanted touching or brushing up against someone. It's all there. Stalking is explicitly included too. Plus, it addresses the very real threats happening on the screens we stare at every single day by specifically defining and penalizing gender-based online sexual harassment. So, the boundary of your personal safety now legally extends to both the physical street and your digital presence. Finally, Section 5, institutional accountability and the duty to protect. We've talked a lot about the individuals committing these acts, but how do the laws hold the actual organizations accountable? Because it's not just about punishing the harasser, it's about making sure the places where you work and learn actually have your back. Under the original law, Republic Act 7877, there's this concept called solidary liability. Here's how it works. Step 1, you report your manager's inappropriate behavior to HR or the head of the office. Step 2, your company takes absolutely no immediate action. They just ignore it. Well, Step 3, because of their inaction, that institution now becomes legally and financially liable for damages, right alongside the offender. They literally cannot wash their hands of it if they knew and did nothing. And the Safe Spaces Act actually doubles down on this accountability. It holds employers and school heads accountable not just for failing to act on reports, but for failing to proactively implement their legal duties in the first place. They are strictly required to set administrative penalties for gender-based sexual harassment within their spaces. If a school or an office fails to create these frameworks or just ignores the reports coming in, they are in direct violation of the law. As we wrap up this explainer, I really want to leave you with this question. Are the institutions you interact with every single day genuinely fulfilling their legal duty to keep you safe? We've seen how the definition of harassment has evolved from these very narrow transaction-based abuses of power under Republic Act 7877 all the way to the incredibly broad protections of the Safe Spaces Act, covering our streets, our online lives, and gender-based slurs. Knowing the law is definitely the first step in ensuring your spaces are truly safe. So take a hard look around your own workplace or campus. Do they actually have the required reporting frameworks in place? Think about it and stay informed.
Imagine for a second that you are a spouse who suspects the absolute worst.
Right.
You hire someone, you track the movements, and finally, you catch your partner in the act. You walk right into a hospital room, and there is your spouse lying on the exact same bed with another person.
Which is, the ultimate nightmare scenario.
Exactly. To you, to me, to anyone with a pulse, that is the ultimate betrayal. Case closed. But imagine taking that to a judge, standing in a courtroom and having the judge look at you and say, well, because of the address on their driver's license, this isn't a crime.
Yeah, it sounds like a bad joke, honestly.
It really does. But it is a very real, very famous court case. And it is exactly the kind of mind-bending legal logic we are tearing into today. Welcome to the Deep Dive.
Glad to be here.
Whether you are, a law student desperately trying to understand the nuances of the penal code before an exam, or you're just someone endlessly fascinated by the invisible, sometimes bizarre rules that govern human behavior, you are in the right place. We have a massive, fascinating mission ahead of us today. We are examining a comprehensive legal syllabus authored by Lorenzo U. Padilla. It focuses heavily on Criminal Law 2, Title 11, which is Crimes Against Chastity from the Philippine Revised Penal Code.
Yeah, and we are also layering in the vital modern updates to these laws, specifically Republic Act 7877 and Republic Act 11313.
Right, because things have changed a lot. But our goal today is to go far beyond just, reciting legal statutes, right?
Mm-hmm.
Reading a syllabus cover to cover would be an excruciating experience for everyone.
Oh, it would be the worst. No, instead, we're going to extract the profound why behind these rules. We are looking at the exact mechanics of how society takes the messiest, most emotional aspects of human existence, intimacy, betrayal, trust, personal space, and tries to force them into a rigid, codified system of law.
It's about understanding the historical anxieties and the moral philosophy that actually birthed these laws in the first place. Okay, let's unpack this. Because that tension between human reality and legal text is where the most incredible stories live. We're going to look at everything from how the law treats the vows of marriage, to how it judges a sleeting touch in a crowded room, to how a marriage certificate can literally act as a get-out-of-jail-free card.
It's a wild ride.
So let's start at the absolute bedrock of traditional societal structure, which is the marital vows. We are diving straight into the deeply contrasted crimes of adultery and concubinage.
Yeah, and this is the perfect foundation because these two crimes offer a stark, unfiltered look at how historical gender dynamics and economic anxieties were basically hardwired into the penal code.
Right.
If you look at Title 11 of the Philippine Revised Penal Code, adultery and concubinage are not just different degrees of the same crime. They are fundamentally distinct offenses with entirely different elements, burdens of proof, and philosophies of punishment.
Let's look at adultery first, which falls under Article 333. The law states that adultery can only be committed by a married woman and a man who is not her husband.
Which is a very specific framing.
I want to pause right there, actually, because the exclusivity of that definition is startling to a modern ear. The crime of adultery, by its strict legal definition here, is exclusively a crime committed by the wife and the person she sleeps with.
Right.
So a married man who sleeps with a single woman is not committing adultery under this specific article.
That is correct. The indispensable core element is the legal marriage of the woman. And the way the courts measure and punish this offense is relentless.
How so?
Well, if we look at the jurisprudence, the body of past court decisions that act as a trail of breadcrumbs for how a law is actually applied, we see a case called People versus Zapata and Bondoc.
Okay.
The Supreme Court ruled that adultery is an instantaneous crime. It is not a continuing state of being. It is consummated and legally completed at the exact moment of carnal union.
Wow. Let me make sure I understand the gravity of that. If it's an instantaneous crime, that means if, say, a private investigator documents an ongoing affair over the course of an entire year.
The prosecutor could theoretically file a separate, distinct criminal charge for every single documented encounter.
Wait, really? Every single time?
Yes. Each act of sexual intercourse constitutes a brand new, separate crime of adultery. It is an incredible compounding of legal liability.
That is heavy. The law doesn't view an affair as a single breach of contract. It views it as a series of isolated, punishable explosions.
Exactly.
But let's inject some messy human reality into this rigid structure. Because, not every marriage is a sanctuary. What if the husband was profoundly abusive? Or what if he just packed his bags, walked out the door, and abandoned his wife entirely, leaving her with absolutely nothing?
It's a fair question.
If she eventually finds someone else, does the law offer her any grace?
You would hope that a modern concept of equity would apply, right? But the historical penal code is unyielding here. The syllabus brings up a very telling case, U.S. versus Serrano.
What happened there?
The defense argued that the husband's complete and unjustified abandonment should excuse the wife's subsequent infidelity. But the court drew a hard line. They ruled that abandonment without justification is only a mitigating circumstance. It is not an exempting circumstance.
So she still gets convicted. She just might get a slightly shorter sentence.
Yes, exactly. The court's reasoning was deeply institutional. They stated that a breach of fidelity is not excused by abandonment because the offending spouse has legal, civil avenues available.
Like what?
She could file a civil suit for financial support. The court essentially said, you cannot use his failure to fulfill his marital duties as an excuse to break your own.
That is a staggering burden. Like,
Yeah.
starve if you must, or go through the agonizing process of a civil suit, but do not seek comfort outside the marriage.
Yeah, it's very harsh.
And it gets even more tragic when you look at the case of People versus Alberto.
Oh, that case truly tests the limits of legal empathy. In People versus Alberto, the accused woman genuinely believed her husband was dead. He had been gone. She was living in a time of extreme want and sheer desperate necessity. Another man stepped in, offered her a helping hand to survive, and out of that profound necessity and gratitude, she gave herself up to him.
Okay, I think I see where this is going.
Yeah. Then, miraculously or tragically, the husband returns.
He comes back from the dead, legally speaking, and files charges against her.
He does. And the court held that her responsibility was mitigated twofold by her belief that he was dead and by sheer necessity. But the crime of adultery still fundamentally existed. She was still held legally liable.
It is a chilling reminder that the law, at least in this historical iteration, values the unbroken seal of the marriage contract over almost any human context. The desperation for survival doesn't erase the crime, it just softens the blow of the gavel.
Exactly.
But let's flip the perspective. We've seen the relentless standard applied to the wife. Let's talk about the husband. When a married man steps out, we are no longer talking about adultery. We are talking about concubinage under Article 334.
And the contrast is jarring, frankly. Unlike adultery, a married man does not commit a crime simply by having a secret, isolated act of sexual intercourse with a woman who is not his wife.
Right.
To be guilty of concubinage, the married man must commit his infidelity in one of three highly specific, highly visible ways.
I was reading these three requirements, and they seem almost intentionally designed to be impossible to meet.
They are very tough.
The first way is that he keeps a mistress in the conjugal dwelling, like he literally moves her into the family home. The second is that he has sexual intercourse with a woman who is not his wife under scandalous circumstances.
Yeah.
And the third is that he cohabits with her in any other place.
Those are the only three paths to a concubinage conviction.
So the double standard is blinding. For a wife, a single highly secretive act is a crime. For a husband, he basically has to put his infidelity on a billboard or force his wife to live under the same roof as his mistress.
Right.
What is the legal philosophy that could possibly justify such a massive disparity?
To understand that, we have to look at the underlying anxieties of the era that drafted these laws. Cases like U.S. versus Mata and legal commentators analyzing the Revised Penal Code point to a very specific biological and economic terror.
Which is?
The gist of the crime of adultery, in the eyes of the law, is the danger of introducing spurious heirs into the family line.
Spurious heirs. It's the biological Trojan horse argument.
Yes.
The fear is that because the wife is the one who bears children, her infidelity carries the risk of sneaking a child of another bloodline into the husband's household.
Precisely. It is an attack on the economic structure of the family. The fear is that the rights of the legitimate heirs might be impaired, and a man might be forced, by law and by deception, to spend his life supporting and maintaining a child that does not share his blood.
That's fascinating.
Adultery, historically, was viewed as much as a crime of economic fraud and property theft as it was a moral failing.
That makes a cold, clinical kind of sense. If the husband cheats, his biological child might be born, but it is born outside his household. It doesn't threaten the immediate inheritance structure of his legitimate family in the exact same physical internal way.
That is the exact rationale the courts used. Because the husband's infidelity does not bring spurious offspring into the legitimate family structure, concubinage is punished less severely, and the requirements are radically different.
Wow.
Because the internal biological threat isn't present, the law shifts its focus. In concubinage, the law isn't policing the bloodline. It is policing the public insult to the wife and the societal scandal. That is why the requirements, scandalous circumstances, or cohabitation are so public and continuous.
But even proving those public requirements seems like a Herculean task. Let's look at scandalous circumstances. A layperson might think, well, the whole neighborhood is gossiping, that's a scandal. But legally, the bar is astronomically high.
It is incredibly rigid. The syllabus cites U.S. versus Campos Rueda. In this case, the offended wife hired private investigators to watch the conduct of her husband and his paramour.
Right.
The spies documented everything, but the court ruled that there were no scandalous circumstances. Why? Because the acts were done in secret and only the hired spies saw them.
Are you kidding?
Nope. If no one else in the general vicinity notices, there is no public scandal.
So the fact that the infidelity happened is irrelevant. The fact that the wife has absolute proof is irrelevant. If the neighbors didn't gasp, it's not a crime.
The neighbors are essentially the jury for the element of scandal. We see this painfully illustrated in U.S. versus Casapong.
What happened in that one?
The offended wife took the stand and testified that she personally saw her husband and the other woman lying side by side, and she saw them going places together. She was devastated.
Understandably.
But the court stated her testimony was insufficient. To be scandalous, the acts must be so imprudent, so wanton, that they offend the modesty and the innate sense of morality of the community. Private grief does not equal public scandal.
That brings us right back to the hook I opened the show with, the hospital case. People versus Santos. Because if scandalous circumstances is hard to prove, the third requirement, cohabitation, is arguably harder.
People versus Santos is a masterclass in strict statutory interpretation. The offended wife walks into a room in the Philippine General Hospital. She surprises her husband lying on the exact same bed with another woman. She catches them red-handed.
And any rational person would say, well, that's it. He's sharing a bed with her. That's cohabitation.
But the court looked at the definitions. Cohabitation legally means dwelling together in the manner of husband and wife possessing a shared domicile.
Oh, wow.
The court examined the facts. The man had his living quarters assigned at the hospital, and the woman had her actual permanent home on Taft Avenue. Therefore, they did not share a domicile.
So they let him off.
The court ruled that a single encounter on a hospital bed, even if caught in the absolute act, is merely a transient interview for unlawful intercourse. It is not cohabitation.
A transient interview for unlawful intercourse. The linguistic gymnastics required to look at two people in a bed and call it a transient interview just to avoid a conviction is staggering.
It really is.
It proves that the law here has zero interest in policing a broken heart or a broken vow. It is entirely obsessed with the structural, public-facing integrity of the family unit.
It is a profound realization. The marital laws in the Revised Penal Code are institutional protections. They protect the bloodline from spurious heirs, and they protect the public face of the marriage from open, undeniable humiliation. Everything else, the emotional devastation, the private betrayal, is left outside the courtroom door.
So we have established how the law acts when it has a marriage contract to anchor it. It looks at bloodlines and addresses. But what happens when the law has no marriage to rely on?
That's where things get very murky.
Right. What happens when a court has to judge a fleeting moment of physical contact between two people in public? How does it decide if a crime occurred? This takes us from the structural bounds of marriage into a highly psychological arena, the battleground between acts of lasciviousness and unjust vexation.
This area of the law, found under Article 336, is incredibly complex because it attempts to criminalize intent. Acts of lasciviousness involves acts of lewdness committed under circumstances that are similar to rape.
Meaning what, exactly?
Meaning they are executed with force, intimidation, when the victim is deprived of reason, or if the victim is under 12 years old. However, the physical act itself might not be intercourse. It might be a forcible kiss, an unwanted embrace, or a touch.
And the dividing line between a serious sexual crime and a minor annoyance rests entirely on what is happening inside the offender's brain.
Exactly.
If a man grabs a woman and kisses her against her will, the physical act is undeniable. But the court has to determine the charge. Was it acts of lasciviousness, or was it merely unjust vexation?
That is the razor's edge. Unjust vexation means you annoyed, irritated, or vexed someone, but you did not harbor a lewd design. Acts of lasciviousness means you were driven by a specific lustful intent.
Which is so hard to prove.
It is a massive evidentiary problem. As the Supreme Court wisely noted in U.S. versus Gomez, there is no inflexible scientific rule to measure a purely mental process like lust.
I used the analogy of an X-ray machine earlier, and this is where that machine totally shorts out. You can X-ray a broken bone, but you cannot X-ray a person's soul to see if they were feeling lust or just spite. So how on earth does a judge figure it out?
By becoming a forensic director, the courts infer the internal intent from the external environment. They scrutinize the overt acts, but more importantly, they scrutinize the exact physical setting of the crime. The environment completely dictates the legal interpretation of the intent.
It's like the law says, tell me about the lighting, the set design, and the extras in the background, and I will tell you what the lead actor's motivation was. Yeah. The syllabus has two contrasting cases that perfectly illustrate this madness. Let's look at the first one. People versus Ano Nuevo. Set the scene for us.
Okay, so a man approaches a woman from behind. He forcibly embraces her, kisses her on the cheek, and fondles her breast.
Hearing that physical description, it sounds like an undeniable act of sexual violence. It sounds like acts of lasciviousness.
It does, but we have to look at the set design. Where did this happen? It happened inside a Catholic church in the broad daylight presence of a crowd of people.
Okay.
Because of that specific environment, the court ruled that this was unjust vexation, not acts of lasciviousness.
Wait. Because they were near a pew, the law assumes he wasn't feeling lust.
The court's reasoning was deeply environmental. They argued that the religious, solemn atmosphere of a church, combined with the presence of a crowd, entirely ruled out the possibility of lustful designs.
That is wild.
The court concluded that a rational person would not attempt to satisfy sexual lust in that specific setting. Therefore, his motive must have been something else. He did it to spite the girl, to embarrass her publicly, or to aggressively bully her into accepting him as a lover. Because the set was a holy place, the intent could not legally be lust.
The holiness of the building acts as a legal shield against a sexual charge. That is wild. But contrast that immediately with the second case, U.S. versus Gomez.
In U.S. versus Gomez, we have a very similar physical act. A man embraces and kisses a woman against her will. He touches her. But this happens in a dark movie theater while the crowd is entirely focused on the screen.
And the verdict.
Acts of lasciviousness.
Wow.
The court ruled that because the lights were out, the setting was inherently intimate, and the potential for discovery was lowered by the darkness and distraction, it was highly logical to infer that his internal feeling was genuinely one of lasciviousness. The shadows of the theater proved the lewd design in a way the bright lights of the church negated it.
So the law is incredibly malleable based on the environment. But I want to push back on this. What if the offender's motive is explicitly stated, and it is undeniably not lust, but the physical act itself is incredibly degrading? Does the environment or the stated motive still save them?
That is a crucial boundary test, and the syllabus addresses it with a disturbing case. U.S. versus Beloses. In this scenario, a man compelled a girl to take off all her clothes and dance naked in front of him and others.
Which is horrifying. But what was his stated motive?
His dominant motive, which was proven in court, was not sexual desire. It was pure vindictive revenge because she had failed to pay a financial debt. He was using public humiliation as a debt collection tactic.
So if we follow the logic of the church case, if his dominant motive is revenge, not lust, it should be unjust vexation, right?
You would think so, but the Supreme Court drew a hard, unyielding line. They ruled that compelling a girl to dance naked is always an act of lasciviousness, regardless of the dominant motive of revenge.
Ah, I see.
The court stated it was impossible to believe that there was no admixture of lasciviousness in the act of forcing a woman to strip and dance. The very essence of the physical act was so inherently lewd that the court refused to let the revenge motive override it.
So there is a hierarchy of inference. The environment can define a fleeting touch, but if the act itself crosses a certain threshold of inherent lewdness, the law ignores the setting and ignores the stated motive.
Precisely.
And there's one more technicality about acts of lasciviousness that I found fascinating. There is no such thing as an attempted charge, right?
Correct. The jurisprudence, specifically the case of People versus Famularo, establishes that acts of lasciviousness only admit of one stage of execution, consummated. There is no frustrated or attempted stage in the eyes of the law.
Why is that? With murder, you have attempted murder if the bullet misses. Why not attempted lasciviousness?
Because of the nature of the abuse. The logic is that the moment you perform the overt act, the moment the unwanted kiss lands or the touch occurs, you have already accomplished your lewd purpose. You have already fundamentally abused the victim's chastity. You do not need to finish a larger sequence of events for the crime to be complete. The violation happens at the point of contact.
We've seen how the court wrestles with intent in these fleeting public moments, but the law changes its posture entirely, and the definitions become even more intricate when the environment involves a position of power or a profound breach of trust.
Yes, absolutely.
When the threat isn't a stranger in a theater, but someone inside your own home or community. Let's examine the complexities of seduction.
When we talk about seduction in a legal context, we must strip away any romantic connotations. Legally, seduction is the act of enticing a minor to unlawful sexual intercourse, and it occupies a very specific age bracket. The minor must be 16 years old or over, but under 18 years of age. If the victim is under 16, the law immediately classifies the act as statutory rape, and the concept of consent becomes legally irrelevant. Seduction is strictly for that 16 to under 18 window.
And the Penal Code splits this crime into two distinct categories: qualified seduction and simple seduction. Let's unpack qualified seduction first, under Article 337.
Qualified seduction is committed when the intercourse is accomplished through the abuse of authority, confidence, or a specific recognized relationship. The law doesn't leave this to interpretation. It provides an explicit list.
Like who?
It includes a public authority, a priest, a house servant, a domestic, a guardian, a teacher, or any person entrusted with the education or custody of the minor. It also explicitly includes incestuous dynamics, like an ascendant seducing a descendant or a brother seducing a sister.
What stands out to me about qualified seduction is what the prosecution does not have to prove. They do not have to prove that the offender lied or used deceit.
That is the core feature of the law. The assumption is that the authority figure's position inherently compromises the minor's ability to freely consent. The authority, the power dynamic itself, acts as the coercive force.
Right.
Deceit is presumed by the very nature of the relationship. And how the courts have interpreted some of these roles is deeply revealing. Take the term domestic.
Let's really look at that word, because when I hear domestic, I think of a hired employee, a maid, a driver, a butler.
But the law assigns a much broader, deeply psychological meaning to it. According to cases like U.S. versus Santiago, a domestic is not just an employee. It is anyone living under the same roof, pertaining to the same house, who shares the confidential intimacy of the family.
Wow.
In one historical case, a distant relative who merely secured board and lodging in the house of the victim's aunt was legally classified as a domestic.
Because they shared the dinner table, they lived as one family unit, which bred a level of trust and intimate access. But the syllabus draws a really sharp, specific contrast with a traveling salesman.
Yes. And this originates from a decision by the Supreme Court of Spain, which heavily influenced the Philippine Code. The scenario is a traveling salesman who stops at a public inn and seduces the innkeeper's teenage daughter. The court ruled that the salesman is not a domestic.
Even though he is technically sleeping under the same roof.
Exactly. Because a transient guest at a commercial inn is not expected to receive or give the sentimental and confidential manifestations of intimacy that are exchanged within a private household.
That phrasing is incredible.
It is. It is the breach of that specific, under-the-roof familial trust that elevates the crime to qualified seduction. The law is guarding the sanctity and the presumed safety of the hearth.
Sentimental and confidential manifestations of intimacy. It's almost poetic language for a penal code. And speaking of the ultimate sanctuaries of trust, the syllabus mentions the role of a priest, also detailed in a case titled U.S. versus Santiago.
It is a profoundly disturbing case that illustrates the absolute extreme of abused ascendancy. A young woman went into a church to confess. The priest utilized the absolute sacred confidence of the confessional to kiss her, embrace her, and ultimately have sexual intercourse with her on the floor of the church.
That is terrible.
The court swiftly ruled this as qualified seduction. The priest weaponized his spiritual authority to commit the act.
The power dynamic there is so absolute it's suffocating. But that is qualified seduction, where the offender wears a badge, a collar, or lives in your home. Let's shift to the other side. Simple seduction under Article 338. In this scenario, the offender is just an average person, no inherent authority. So how do they commit the crime?
Because there is no built-in authority to abuse, the law requires the active presence of deceit. In simple seduction, the offender must use deceit to entice the minor into sexual intercourse.
What does that usually look like?
In the vast majority of jurisprudence, this deceit takes a very specific form: an unfulfilled promise of marriage. The minor yields her virtue specifically because she relies on the solemn promise that they will be wed.
I want to play devil's advocate here and really test the boundaries of deceit, because the syllabus outlines some scenarios where you would think a crime occurred, but the law says no. What if a man sleeps with a 17-year-old girl and then afterwards, as he's leaving, promises to marry her and then disappears?
The law says that is not simple seduction. According to the precedent set in U.S. versus Sarmiento, a promise of marriage made after the woman has already yielded her body could not possibly have induced her to surrender in the first place.
Oh, I see. It's a question of causality.
Exactly. The deceit must be the causal factor. If the promise came after the act, there was no deceitful inducement. The timeline dictates the liability.
Okay, that follows a strict logical sequence. But here's the scenario that genuinely frustrated me. What if a man promises to marry the girl? He uses that promise to seduce her, but the girl knows for an absolute fact that the man is already legally married.
Again, relying on the doctrine in U.S. versus Sarmiento, the court ruled that this does not constitute deceit.
Why? I mean, he lied to her to get what he wanted.
But the law requires the victim to have been genuinely deceived. If the minor knows the man is already married when she surrenders herself, there is a fundamental absence of reliance.
Wait.
The court's logic is that she could not have genuinely, rationally relied on a promise of marriage when she knew full well that he was legally incapable of fulfilling it.
This logic feels incredibly harsh. The law is dealing with a 16 or 17-year-old minor, but it basically says if I make a promise I legally cannot keep and you know it, you should have known better. It feels like blaming the victim for her own naivety.
I know, it really does.
If I signed a business contract with someone I know is bankrupt and they don't pay me, the court says, well, you knew he had no money, so it's not fraud. The court applies that same clinical business logic to a teenager's romantic coercion.
It is a highly clinical, almost contractual view of human interaction. The law assumes a baseline level of rational calculation on the part of the victim, even a minor. The law protects the naive, but it argues it cannot offer legal protection to someone who willingly, knowingly walks into an obvious impossibility.
You can clearly see how these laws, drafted generations ago, were built for a very specific societal structure. They relied heavily on traditional concepts of the domestic parlor room, the confessional, the formal binding promise of marriage.
Very much so.
But the world didn't stay in the parlor room. Society evolved violently. Women entered the workforce and higher education in massive numbers. The dynamics of power shifted. The threats weren't just the traveling salesman or the house guest anymore. They were the boss, the manager, the professor. The old laws required physical act intercourse or acts of lasciviousness to trigger a crime. But what about the subtle psychological economic coercion of a modern office?
That realization forced a massive paradigm shift in Philippine law, which brings us to the evolution of protection and modern sexual harassment laws. The old Title 11 of the Penal Code was entirely inadequate for the modern workplace. It could not diagnose economic coercion.
So what do they do?
So the legislature created Republic Act 7877, the Anti-Sexual Harassment Act of 1995.
This law specifically targets the spheres of work, education, and training. And the shift in legal philosophy here is staggering. Under the old crimes against chastity, you had to prove a physical violation. Under RA 7877, you don't.
Not at all. Under RA 7877, the gravitational center, the very essence of the offense, is the mere demand, request, or requirement of a sexual favor.
I want to make that crystal clear. No one has to be touched for this crime to be committed.
No physical contact is required. Furthermore, the law explicitly states that it is entirely immaterial whether the victim accepts or rejects the demand.
Really?
Yes. The crime is not the act of sex. The crime is the abuse of the power dynamic to make the demand in the first place. This applies to employers, managers, supervisors, teachers, professors, coaches, anyone who holds authority, influence, or moral ascendancy over another in those specific environments.
I like to think of RA 7877 as policing a corrupt toll booth. If you are driving on a highway and you reach a toll booth and the operator demands a bribe to let you pass, the crime is the extortion.
Exactly.
In the workplace, if a boss demands a sexual favor to give you a promotion, or a teacher demands a favor to give you a passing grade, it's a highly transactional form of extortion. They are holding the keys to your livelihood or your education and using them as a weapon.
That is a highly accurate analogy. RA 7877 is fundamentally transactional. Give me this sexual favor and I will give you favorable compensation, a promotion, or a scholarship. Or equally illegally, refuse me and I will create a hostile, intimidating work environment that diminishes your opportunities.
Right.
The law finally recognized that economic power and educational authority can be just as violently coercive as physical force.
But the evolution of the law didn't stop there, because society realized that harassment isn't confined to a closed office where a boss holds a paycheck over your head. It happens on the sidewalk. It happens on public transit. It happens relentlessly on the internet. And that realization birthed Republic Act 13313, the Safe Spaces Act.
The Safe Spaces Act, passed much more recently, expanded the scope of protection exponentially. If RA 7877 protects the transactional toll booth of your career, RA 13313 protects the air we breathe in public.
I love that framing.
It defines and heavily penalizes gender-based sexual harassment in streets, public spaces, and online platforms.
And what I find so impressive about the Safe Spaces Act is how granular and specific it is about the realities of modern daily life. It doesn't use vague terms. It lists the behaviors.
It leaves no room for ambiguity. It explicitly penalizes cursing, wolf whistling, catcalling, leering, and intrusive gazing. It punishes taunting and unwanted invitations. It goes after misogynistic, transphobic, homophobic, and sexist slurs. It covers the persistent telling of sexual jokes, relentless requests for someone's contact details against their will, and importantly, online gender-based harassment like cyberstalking, uploading unauthorized media, or sending unwanted sexual images.
It is an incredible historical contrast.
Yeah.
We started this deep dive looking at a penal code where a woman literally had to prove her neighbors were scandalized by her husband's affair to get justice.
Yeah, quite the jump.
Now, we are looking at a law that says if a complete stranger on the street makes an intrusive, leering gaze that threatens your psychological sense of personal safety, that is a punishable crime. It is a profound legal recognition that words, stares, and digital harassment can be deeply violating without a single finger being laid on the victim.
And RA 13313 goes a step further by imposing what we call institutional accountability. It mandates that employers or school heads have a duty to prevent these acts.
That's a big deal.
It is. If an institution fails to implement its duties under the Safe Spaces Act, like failing to set administrative penalties or failing to take immediate action on reported acts of harassment, that failure is actually a punishable offense in itself. The institution cannot just look the other way. They are legally conscripted to maintain the safety of this space.
The net of protection has widened significantly for adults navigating public and professional spaces. But as we pivot into our next area of analysis, we have to look at how the law provides absolute, unyielding protection for the most vulnerable members of any society.
Children.
This is a heavy topic.
It is. We are moving from the realm of harassment to the darkest, most terrifying corners of the legal syllabus, exploiting the vulnerable, trafficking, and white slavery.
These are the crimes where human beings are stripped of their humanity and treated purely as commodities. Let's begin with Article 340 of the Revised Penal Code, corruption of minors.
Okay.
This article penalizes anyone who promotes or facilitates the prostitution or corruption of a minor to satisfy the lust of another person. So the crucial distinction here is that we aren't necessarily talking about the person committing the physical abuse. We're talking about the middleman.
Exactly. The legal nuance here is that the offender under Article 340 does not need to perform the unchaste act themselves. The pimp, the procurer, the facilitator is the one bearing the liability for the act of facilitation.
That makes sense.
The law recognizes that the infrastructure of abuse, the people arranging it, are just as dangerous as the abusers. And originally, under older Spanish-era interpretations of the law, there was a fierce debate about habituality.
Meaning, did you have to be running a full-time prostitution ring to be charged? Or was setting it up one time enough to make you a criminal?
Right. The law and jurisprudence evolved to make it crystal clear. Habituality is absolutely not required. A single, isolated act of placing a minor at another's disposal for immoral purposes is enough to violently breach the law.
Wow, just one time.
But as syndicates grew more sophisticated, the old revised penal code wasn't enough to handle the industrial scale of modern trafficking. So the Philippines enacted Republic Act 7610, the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act.
When you read the provisions of RA 7610, it is heavy. It is dealing with the absolute worst of human nature.
It is severely penal, and rightfully so. RA 7610 drastically increases the penalties for child prostitution and trafficking. It aggressively pursues anyone who derives profit from child prostitution.
Including businesses, right?
Yes. This includes the owner, manager, or staff of any establishment, a sauna, a disco, a bar, a resort that serves as a front or cover for prostitution.
There is a vital philosophical and legal safeguard in RA 7610 that we must highlight. Under older laws, like Article 202 of the Penal Code, which dealt with vagrants and prostitutes, a child caught in a prostitution raid might technically be viewed by the system as an offender, a delinquent.
Which is horrific to think about now.
RA 7610 completely obliterates that perspective.
It was a necessary moral correction. Under RA 7610, child prostitutes are strictly legally viewed as victims. They are defined as children exploited in prostitution. They are never criminals in the eyes of this law. They are the victims of the adults who profit from their abuse.
Which makes sure the state's resources are aimed at rescuing the child and destroying the syndicate.
Exactly.
And the law goes aggressively after the supply chain itself through child trafficking. The syllabus details the terrifying specifics of what constitutes attempted child trafficking under RA 7610. It is so much more insidious than the stereotypical image of kidnapping someone off the street.
The methods of modern trafficking are deeply bureaucratic and medicalized.
Right.
The law considers it attempted child trafficking if a doctor, a nurse, or a hospital employee simulates a birth for the purpose of trafficking a child. It is attempted trafficking if a pregnant mother executes an affidavit of consent for adoption in exchange for financial consideration.
Meaning she is legally documenting the sale of her unborn child.
Yes.
It is horrifying. It even covers agencies that recruit couples specifically to bear children for the purpose of trafficking, or scouts who target low-income families in hospital wards looking for children to buy.
It is the horrific reality of treating human beings as inventory for a supply chain. And the law tries to cut off the head of the snake at every possible node. The recruiter on the street, the corrupt doctor faking the birth certificate, the bar owner looking the other way.
And we see this focus on the business aspect in Article 341 of the Revised Penal Code as well, regarding the white slave trade.
Yes. Article 341 deals with engaging in the business of prostitution, profiting from it, or enlisting women for it. And just like with the corruption of minors, the Supreme Court ruled in the case of People versus Bueno that habituality is not an element.
A single act of enlisting a woman is sufficient for a conviction.
And the law extends liability to the absentee owners of these businesses. In People versus St. Maria, the defense argued that because the owner of a house of ill repute was not physically present during the police raid, they couldn't be held liable.
Oh, I'm sure they tried.
The court struck that down entirely. They held that the maintainer or manager of the business carries the liability simply by maintaining it. Ignorance of a specific raid does not absolve the maintenance of the infrastructure.
So trafficking and white slavery are largely about the business of moving and selling humans.
Mm-hmm.
But the penal code also has very specific, intricate definitions for when someone is forcibly taken away, not to be sold to a third party, but for the direct, immediate satisfaction of the person doing the taking.
That's right.
And this takes us to the crime of taking, forcible versus consented abduction.
This area of the law is a fascinating study in how intensely a court focuses on the specific motive behind a physical act. Let's look at forcible abduction under Article 342.
Okay.
The law defines this as taking a woman against her will, regardless of her age, civil status, or reputation, with lewd designs.
To anyone outside the legal profession, taking a woman against her will sounds exactly like kidnapping. If someone uses violence to throw me in the trunk of a car, I am thinking, I have been kidnapped. How does a judge look at that exact physical act and distinguish between abduction, kidnapping, and coercion?
The magic legal ingredient, the gravitational center of the charge, is lewd design. The entire classification of the crime hinges on why the offender took the victim. Let's look at how the jurisprudence handles this. In the case of People versus De La Cruz, a woman was dragged from the doorway of her house and forced into a waiting truck by violence and intimidation.
That sounds like a textbook abduction.
However, the facts of the case showed she was not molested and no attempts were made against her chastity. The court ruled that because there was no sexual intent, this was not forcible abduction, it was grave coercion.
Oh, wow.
The offender just wanted to force her to go somewhere against her will.
And what if the violent taking is done to detain her for a long period, say for ransom, but still without any sexual intent?
Then the crime shifts again. As the court noted in People versus Crisostomo, if a woman is locked up without lewd designs, the crime is kidnapping or serious illegal detention under Article 267.
So the intent changes everything.
The legal philosophy is that kidnapping is fundamentally a crime against liberty. Forcible abduction is fundamentally a crime against chastity. The lewd design is the dividing line.
But how does a prosecutor prove a lewd design? It brings us back to the X-ray machine problem. How do you prove what was in the abductor's mind?
Through the overt conduct surrounding the taking. If the abductor kisses and embraces the victim while dragging her away, that is strong evidentiary proof of lewd design. But there is also a very unique, almost bizarre indicator of lewd design detailed in the syllabus: a hurried marriage ceremony by force.
I read this and had to read it twice. Explain the case of People versus Hatib Tallah.
In People versus Hatib Tallah, the offenders abducted a minor and immediately forced her through a hurried marriage ceremony. They knew full well she couldn't legally consent because of her age and the coercion, but they thought the ceremony would legitimize the taking.
That is absurd.
The court viewed this fake marriage ceremony not as an honorable intention to build a life together, but as an artifice. It was a trick, a cloak sought to escape the criminal consequences of their acts. The court ruled that using a forced marriage as a cover-up is the ultimate proof of unchaste, lewd designs.
It is exactly like a bank robber stealing $1 million, walking into the lobby and trying to open a checking account with the stolen cash to make it look legitimate. Like, look, Your Honor, we went through a ceremony. Everything is fine.
Exactly.
And the court says, no, the fact that you forced a fake ceremony is the absolute proof of your criminal intent. It is incredible logic. But that is forcible abduction, where violence is used. What about consented abduction under Article 343? How can an abduction, a taking, have consent?
Consented abduction applies to a very specific, historically grounded victim profile, a virgin over 12 and under 18 years of age, and the crime consists of taking her away with her consent, but that consent must be obtained through solicitation or cajolery from the offender, and of course, with lewd designs.
The legal philosophy here is heavily paternalistic. The Supreme Court in U.S. v. Reyes noted that the law's purpose isn't necessarily to punish a wrong done to the girl, because she technically consented. The purpose is to punish the disgrace brought to her family and the alarm caused by the disappearance of a minor who is susceptible to sweet-talking and deceit.
It is extremely paternalistic. It protects the parent's authority and the family's honor. And the physical mechanics of the taking away are interpreted quite broadly.
How so?
Previously, some courts thought the taking had to have a character of permanency, like running away to another province. But in the later case of People v. Ngayo, the court clarified that no matter how short the taking away is, the crime exists.
Just a few hours.
In that specific case, the minor was only hidden in the house of the accused for 5 hours. That brief removal from her parents' home was enough to constitute the taking.
With the cajolery, the act of sweet-talking and solicitation by the offender is absolutely mandatory, right? Yeah.
It is the hinge upon which the crime rests. Without it, there is no crime. The syllabus cites a heartbreakingly simple case that proves this. People v. Palisock.
Right.
A 16-year-old girl, purely out of her own volition, voluntarily goes to the house of the man she loves. She was terrified of her mother's anger at home. She shows up at his door. He is surprised to see her. They talk, and eventually they have sexual intercourse.
She is a minor. They had intercourse. She is out of her home. So it's consented abduction.
The court ruled there was no consented abduction. Why? Because their meeting was almost accidental, and crucially, the man did not solicit her escape.
Oh, wow.
He didn't cajole her into leaving her mother's house. She fled on her own accord. Without his active solicitation, her voluntary taking of herself removes the foundational element of the crime.
It really emphasizes how surgically precise the law tries to be about exactly who initiated the disruption of the family home. Which brings us to our final and perhaps most mind-bending exploration.
Okay, let's do it.
We have dissected the crimes. We know what constitutes an offense, but what happens after the crime is committed? Getting these specific crimes into a courtroom involves a bizarre, intricate set of rules regarding prosecution, pardon, and liability.
This is where the mechanics of justice become deeply entangled with social policy. The most fundamental rule here, found in Article 344 of the Revised Penal Code, is that crimes like adultery, concubinage, seduction, and abduction are classified legally as private crimes.
Let's break down that term. For a layperson, if the police catch someone committing a murder or a bank robbery, the state just prosecutes them automatically. The prosecutor files the case on behalf of the people. But for private crimes, that process stops.
Exactly. For private crimes, the state cannot prosecute de officio. De officio essentially means on its own initiative, by virtue of its office. Think of the state's prosecutorial power like a smoke detector. For a public crime like murder, the minute the state smells smoke, the alarms go off and the fire trucks are coming to kick down the door, whether you want them there or not. But for private crimes, the smoke detector is turned off.
So they wait for a call.
These crimes absolutely require a formal written complaint filed by a very specific authorized person. For adultery and concubinage, it must be the offended spouse. No one else can file it. For seduction and abduction, the law provides a strict hierarchy. First the offended party, then the parents, then the grandparents, then the guardian.
But why? If a crime is a crime, why does the state tie its own hands and refuse to prosecute unless the family explicitly gives them permission to?
The Supreme Court explained the underlying philosophy beautifully in Samelin v. Court of First Instance. It is out of deep consideration for the offended woman and her family.
How does that work?
A public trial for seduction or abduction inherently involves a deeply invasive humiliating examination into the victim's past life, her virginity, her modesty, and the conduct of her family. The law recognizes a harsh reality. The family might prefer to suffer the outrage in private silence rather than go through the painful public mortification, scandal, and discredit of a highly publicized trial.
So the state steps back and says, we will only drag this tragedy into the public light if you explicitly permit us to, because the trial itself might cause you more social harm than the initial crime. It is a fascinating, delicate balance between absolute punitive justice and social privacy. And this immense power given to the private parties extends to the power of pardon.
Yes, the power of pardon in these private crimes is incredibly potent and highly technical. Let's look at adultery and concubinage. A pardon from the offended spouse completely bars criminal prosecution.
Just like that.
But based on the historical Spanish text of the law and cases like People versus Infante, the pardon must be for both offenders. The offended husband cannot go to court and say, I forgive my wife, I want to bring her home, but I want to send her lover to bilibid prison.
Oh, interesting.
The law says no. A pardon for one operates legally as a pardon for both.
And it doesn't even have to be a formal, notarized written pardon, right? The syllabus goes into depth about implied pardon.
Implied pardon and prior consent are incredibly powerful defenses. In the case of Matubis versus Praxides, the husband and wife signed a formal separation agreement. In that document, they explicitly stipulated that they were giving each other the freedom to get any mate and live as husband and wife without interference from the other.
A literal, legally drafted hall pass written into a separation contract.
Exactly. When one of them later changed their mind and tried to file a criminal case for concubinage, the court threw it out. The court ruled that this written agreement constituted an unbridled license for the commission of the act. It was an implied prior consent, which absolutely barred them from invoking the state's help to institute a criminal complaint later. The philosophy is, if you agree to compromise your honor beforehand, you become unworthy of coming to court to demand it be defended later.
That makes a strange, cynical kind of contractual sense. But the most shocking rule regarding pardon and liability involves the power of a marriage certificate. Let's talk about the rule of marriage under Article 344 in cases of seduction and abduction.
This is perhaps one of the most debated and astonishing provisions in the Penal Code. In cases of seduction, abduction, and acts of lasciviousness, if the offender subsequently enters into a valid marriage with the offended party entered into in good faith, that marriage automatically extinguishes the criminal action.
Wow.
If a trial is ongoing, it stops. If a penalty has already been imposed, the marriage remits the penalty.
Meaning the offender goes free. The marriage certificate operates as a literal get-out-of-jail-free card.
It does. And the extent of this benefit is staggering. Let's look at the case of Lateste versus Santos. The Supreme Court ruled on a situation involving an accomplice. The main offender committed the crime with the help of an accomplice. The trial happened. The accomplice was convicted, sentenced, and was already sitting in prison serving his time.
Okay.
Sometime later, the main principal offender manages to marry the victim.
Okay, the principal marries the victim. What happens to the accomplice in prison?
The Supreme Court ruled that the marriage of the principal to the victim immediately entitles the accomplice to be released from prison.
Wait, really?
The marriage extinguishes the criminal liability not just for the principal, but for the co-principals, the accomplices, and the accessories.
I need to process the mechanics of that. If I help my friend commit an abduction and I get caught and go to prison, but my friend stays free long enough to convince the victim to marry him, I get to walk out of my cell. The marriage certificate acts like a legal erasure that wipes the slate clean for every single person involved in the crime.
That is exactly how it functions. And to understand why, we have to look at the foundational legal theory, which ties back to everything we've discussed today about the family unit. The law intensely prioritizes the preservation of the newly formed family.
Interesting.
The theory is that if the victim has chosen of her own free will to forgive the offender and form a legal family with him, sending her new husband to prison would economically destroy that new family. Furthermore, sending his accomplices to prison would keep the stigma and the scandal of the crime alive, bringing shame to the new marriage.
Ah, I see the logic now.
The law decides that preserving the peace, reputation, and financial stability of that specific new family unit is vastly more important to the fabric of society than enacting absolute punitive justice for the original crime.
It is mind-blowing. It really drives home the overarching theme of this entire syllabus. The Penal Code is not just a rigid list of universal right and wrong. It is a highly complex, sometimes messy prioritization of societal values. It values the family unit, or at least the appearance, economics, and structure of it, above almost everything else. And we see that ultimate focus on economics in the civil liability aspects at the very end of the code, right?
Yes, Article 345 mandates the civil liability of the offenders, specifically focusing on the economic support of the offspring. In cases of rape, seduction, or abduction, the offender must support the offspring in every case. And the jurisprudence is relentless in enforcing this economic mandate.
Do you have an example?
Look at People versus Velo. It was a tragic case of multiple rape involving several perpetrators. Because multiple men were involved, it was scientifically impossible at the time to ascertain which specific attacker was the biological father of the resulting child.
So faced with that biological uncertainty, what did the court do?
The court ruled that all the accused must support the offspring. The logic was undeniable. Since any of them might be the biological father, and every single one of them cooperated in directly causing the undesired birth, they collectively share the civil liability to ensure that child is economically supported.
That's a huge ruling.
The state will not let the burden of support fall solely on the victim or society if the attackers can be made to pay.
Wow. That ruling brings us full circle in such a profound way. From the very beginning of our deep dive, looking at the double standards of adultery, aimed at protecting the economic structure of a family from spurious heirs, to the very end, forcing multiple attackers to collectively fund the economic survival of the offspring of their crimes. The law is perpetually obsessed with lineage, economics, and the structural integrity of the family.
It really is the thread connecting it all.
Let's take a breath and recap this immense journey. We started by dissecting the highly gendered, biologically driven double standards of adultery and concubinage. We watched the courts act as theatrical directors, trying to infer a person's soul based on the lighting of a church or a dark theater to define acts of lasciviousness.
What a wild concept.
Right. And then we tracked the vital evolution of the law, moving from punishing breaches of trust in domestic parlor rooms, to creating the transactional protections of the Anti-Sexual Harassment Act, to guarding the public air we breathe with the Safe Spaces Act. We confronted the grim reality of human supply chains and child trafficking, and finally, we navigated the bizarre, intricate courtroom mechanics where a separation agreement or a marriage certificate can literally act as an eraser of criminal liability.
It has been a profound look at how human morality, anxiety, and societal shifts are wrestled into legal text. We've seen how intensely the law scrutinizes intent, environment, and relationships to define a crime against chastity in the physical world.
Yes, the physical world.
But as we close, I want to offer a final thought for you to mull over. As our lives move increasingly away from the physical world and into virtual reality, into the metaverse and generative artificial intelligence, where physical presence isn't required but psychological harm is intensely real, how will the law adapt to punish the lewd designs of a digital avatar?
Oh, wow.
If the Safe Spaces Act protects the physical streets and the current internet, will it be enough to govern fully immersive digital spaces? Or will society be forced to write an entirely new title of the Penal Code to diagnose the morality of the metaverse?
That is a brilliant and terrifying question. How do you possibly prove scandalous circumstances to a neighborhood when the neighbors are just anonymous, shifting usernames in a digital lobby?
Exactly.
That is a frontier for you to explore on your own. Because as we've seen today, that diagnostic tool of the law is always going to be a little bit murky when it comes to keeping pace with human nature. Keep questioning the hidden rules that govern our society, and we will catch you on the next deep dive.
Welcome to The Debate. Imagine committing a crime that is consummated in like a single second. One moment of weakness, one singular action, and you are immediately branded a criminal.
Right. But then imagine your spouse doing the exact same thing, engaging in that exact same betrayal. And the law just, shrugs.
Yeah, it basically looks the other way and essentially asks if any of the neighbors noticed.
Exactly.
Today we are exploring a legal framework where the rules of fidelity change completely depending on whether you are the husband or the wife. So specifically, we're looking at the Revised Penal Code's crimes against chastity. We'll be dissecting the really stark distinctions between how marital infidelity is prosecuted for women, which is defined as adultery under Article 333,
right,
versus how it is prosecuted for men, which is defined as concubinage under Article 334. I will be representing the position that this differential treatment, while undeniably strict, is a necessary pragmatic mechanism designed to protect family lineage.
And I represent the position that this framework is fundamentally unjust, reducing fidelity to mere biological record keeping and establishing, near impossible evidentiary standards that effectively shield male infidelity.
So if you're listening to this and thinking, wait, how could the law possibly justify a double standard for the exact same physical act? You really have to understand the historical and structural priorities of the courts. The law regarding adultery is not actually attempting to enforce an identical standard of moral purity. I mean, if we view this purely as a moral judgment, it will always look unbalanced.
Oh, absolutely.
But the law operates pragmatically to protect a very specific societal structure. If we look back at the precedent set by U.S. versus Mata, the court made it crystal clear. They established the gist of the crime of adultery. The core danger is the introduction of spurious heirs, so illegitimate children, into the family.
Which, it reduces fidelity entirely to biological record keeping.
Well, yes, because at the time these frameworks were built, we didn't have DNA testing. Paternity was a legal presumption.
Right.
If a married woman has an affair and conceives, that child is presumed to be her husband's. So through adultery, the rights of real legitimate heirs are immediately impaired. A man suddenly finds himself legally and financially charged with the maintenance of a child.
And an entire family line, really.
Exactly. A line that is not his own. So because of this biological reality, the courts noted in cases like People versus Zapata and Bondoc that adultery is an instantaneous crime. It is consummated and completed at the exact moment of carnal union. The structural threat, the potential conception of an illegitimate heir, is realized in that single instant. Concubinage, on the other hand, is punished less severely simply because a husband's infidelity, no matter how morally reprehensible, cannot physically bring a spurious offspring into his own legitimate family unit.
Yeah.
The legitimate estate remains biologically intact.
That argument sounds pristine on paper, but it fundamentally breaks down when you look at the human reality of the law.
How so?
Well, by defining the gist of the crime purely around biological lineage, the law effectively creates a catastrophic double standard regarding what actually constitutes a crime in the first place.
Okay.
For a married woman, a single act of sexual intercourse with another man is adultery. Full stop. Instantaneous, just as you said. But for a married man, the precedent in People versus Santos establishes that simply having sexual relations with a woman who is not his wife does not necessarily make him liable for concubinage.
Right, because the act alone doesn't trigger the structural threat to his family's estate. It requires specific conditions to be met.
But look at how staggering those conditions are. To commit concubinage under Article 334, a man must do one of three highly specific things. He must keep a mistress in the conjugal dwelling.
Which is incredibly brazen.
Right. Or he must cohabit with her in any other place, or he must have sexual intercourse under what the law calls scandalous circumstances.
Right.
This creates a bizarre legal reality where male infidelity is largely tolerated or at least entirely unpunishable by criminal law, unless it becomes a prolonged public spectacle.
I see.
It tells society that male infidelity is perfectly acceptable as long as it's discreet. It strips the marital vow of any mutuality.
I mean, I see why you view that as a protection of male privilege, but let's look at how this plays out structurally, particularly when we examine the burden of hardship. You argue that the law is unequal, but the law demands a strict adherence precisely because the consequences of a breach are so absolute. If you allow emotional hardship to excuse adultery, you suddenly have courts forced to litigate the emotional quality of every single marriage before deciding if a spurious heir is legally permissible.
Okay, but if we are going to talk about the burden of hardship, we have to talk about the extreme lack of legal charity afforded to women. This is where the sheer cruelty of the framework becomes impossible to ignore.
Cruelty is a strong word.
But look at how the courts handle abandonment. In U.S. versus Serrano, we see a scenario where a husband completely abandons his wife without any justification. She is left to fend for herself.
Right.
She eventually enters into another relationship, and the court ruled that his abandonment is merely a mitigating circumstance for her subsequent adultery, not an exempting one. The law says she is still a criminal.
Because again, the structural threat of the spurious heir remains, regardless of how badly the husband has behaved.
Yeah, but
The lineage doesn't stop needing protection just because the husband is derelict.
what about the basic human instinct to survive? The historical case of People versus Alberto is absolutely tragic and highlights this perfectly. A woman is living in sheer necessity. Her husband has disappeared and is widely believed to be dead.
Right, a terrible situation.
During a time of extreme want and starvation, she gives herself up to a man who lends her helping hand, literally just to survive. Later, the husband miraculously returns. And what does the law do?
It mitigated her sentence.
Only twofold? She is still branded a criminal for surviving. Now contrast that staggering rigidity with how the law treats male inaction.
You're referring to the concept of consent in these cases?
Exactly. In People versus Cinsano and Ramos, a husband knows his wife has resumed living with another man. He does absolutely nothing to interfere. Instead, he leaves for Hawaii, stayed there for 7 years, and completely abandons his wife and child.
Okay.
When he eventually tries to prosecute her, the court ruled that his inaction meant he consented to her infidelity, barring him from prosecuting her.
Well, that seems like a legal protection for the wife, doesn't it? The court stopped him from punishing her after he abandoned her.
No, it protects his inaction. It establishes that a man can completely abandon his family, provide no support, and the law simply shrugs and says, well, you consented to her finding a new life. It acts as a shield for his dereliction of duty.
I see your point.
Yes, if a woman is abandoned and forms a new relationship to literally stay alive, as in Alberto, the state prosecutes her. The framework ruthlessly penalizes female survival while legally validating male abandonment.
That is an incredibly compelling emotional argument, and I acknowledge the severity of the Alberto case. It is a tragic human scenario.
It really is.
But I must defend the rigidity of the law here because we have to look at the mechanics of the institution. Think of this framework like strict liability in corporate or environmental law.
Strict liability?
Yes. If a factory spills 1,000 gallons of toxic chemicals into a river, the penalty applies strictly because the structural damage to the environment is absolute. It doesn't matter if the factory manager was going through a personal hardship or if a competitor also polluted the river. The law doesn't weigh emotional parity, it measures the damage.
Wait, I have to stop you there. Because a child is not a toxic spill. You can't equate a human life born of hardship to environmental damage.
I'm not equating the child to a toxin, I'm talking about the legal mechanism. Biologically and legally, within the very specific context of inheritance and lineage, an illegitimate heir introduces absolute irreversible disruption to the legitimate family structure. Think of it like introducing a permanent, irrevocable shareholder into a private family company without the CEO's consent.
Wow.
That shareholder now has rights to the dividends, the property, the legacy. That is the damage the law is measuring. Therefore, the law demands strict liability from the wife. The ruling in Serrano specifically notes that a breach of fidelity is not excused by abandonment because the offending spouse has means within the law to compel the husband to fulfill duties imposed upon her by marriage.
So she's supposed to sue him while starving?
The law demands she use legal remedies, going to the courts for support, rather than resorting to self-help that fundamentally threatens the lineage.
I understand the mechanism you're describing, but I'm not convinced by that line of reasoning, because the strict liability only applies to one party.
Right.
If we are talking about strict liability for preserving the marriage, why does the man not face strict liability for breaking his vows? This brings us to the evidentiary chasm between the two crimes.
Okay, let's look at the evidence.
If you're listening and wondering how hard it is to prove these crimes, the burden of proof for women is terrifyingly low compared to the burden for men. For adultery, carnal knowledge can be proved by mere circumstantial evidence.
Yes, that's true.
U.S. versus Legaspi shows that love letters signed by a paramour or being surprised in what the court calls an assignation house, which is essentially just a motel or a brothel used for illicit rendezvous, is entirely sufficient to convict, just being in the wrong place with the wrong correspondence.
Well, because realistically, those circumstances overwhelmingly imply the consummation of that instantaneous crime. The courts don't need a photograph of the act. The context provides the proof of the biological risk.
But now look at concubinage. To prove a man had sex under scandalous circumstances, which is one of the only ways to catch him if he doesn't literally move his mistress into the family home, The courts define scandalous as a reprehensible act that offends public conscience and ruins neighbors' spiritual feelings.
Right.
It literally requires the man to be broadcasting his infidelity. Look at the absolute absurdity of the People versus Santos case. An offended wife surprises her husband in a room in the Philippine General Hospital.
Oh, right, the hospital case.
He is lying on the exact same bed with another woman, and the court ruled it was not cohabitation and not concubinage.
Well, because of the specific living arrangements in that case.
Right, because his assigned quarters were at the hospital and hers were on Taft Avenue. They didn't formally live together, and apparently being caught by your wife in a hospital bed with your mistress wasn't a scandalous circumstance because it was behind a closed door. It defies basic logic.
It defies modern logic, certainly. But the higher evidentiary bar for concubinage is entirely intentional within this framework.
Intentional to protect men.
Intentional to prevent the frivolous destruction of the family unit over private indiscretions. Since the biological risk of a spurious heir isn't present when the man strays, the state has far less interest in policing his private behavior. We have to ask, why are scandalous circumstances the metric? Because in this historical context, a family's honor was a public-facing commodity. The crime of concubinage is only triggered when the man's actions cause public, societal damage to the family's standing.
Okay.
Keeping a mistress in the conjugal dwelling is an unforgivable, undeniable insult to the legitimate wife. Flaunting a mistress publicly destroys the family's social reputation. The law is stepping in to punish the public destruction of the family, not the private moral failure.
That's a fascinating explanation of the history. But consider what that actually does to the definition of a marriage contract. It's like having a labor contract where one employee, the woman, is fired, sued, and faces actual jail time for a single private mistake that no one ever saw.
Yeah.
But the other employee, the man, is only reprimanded if he broadcasts his failure on a massive billboard in the middle of town.
That's quite an analogy.
It fundamentally redefines fidelity for men as merely avoiding public embarrassment. If you can hide it, if you can keep your mistress in a separate house, if you don't offend the neighbor's delicate spiritual feelings, you haven't actually committed a crime. That is not a legal framework protecting a family. That is a legal framework protecting male privilege.
You keep returning to this idea that the law is just a blind shield for male privilege. But if we look at how the law treats the unmarried third parties, the lovers involved in these affairs, we actually see that the law is obsessed with intent, not just gender.
Really?
Yes, it is a highly precise instrument. In adultery, the unmarried man is not automatically guilty just because he had sex with a married woman. The precedent in U.S. vs. Tapiano is crucial here. A man is only guilty of adultery if he knew the woman was married. If he is genuinely deceived by her, he is innocent. The law requires a specific, conscious intent to violate the marital bond of another man. It examines the mens rea, the guilty mind, of the third party.
I am so glad you brought up the unmarried third parties, because this perfectly illustrates how the web of rules constantly defaults to trapping female behavior while providing escape hatches for men.
How so?
Let's look closely at that exact standard. You said an unmarried man must know the woman is married.
True.
But look at the nuance in Tapino. In that case, the unmarried man didn't know the woman was married at the beginning of the relationship.
Right.
But he found out halfway through, and he decided to continue the relationship. The court found him guilty of adultery for all the acts after he gained that knowledge. The trap spring shut on him immediately upon discovery. One act after seeing the wedding ring, and he's a criminal.
Which aligns perfectly with the structural argument. He is now knowingly participating in the threat of introducing spurious errors.
Okay, but now let's look at the unmarried woman, the concubine. She can only be guilty of concubinage if she knows the man is married and she participates in those highly specific, near impossible to prove acts: cohabiting, being kept in the conjugal dwelling, or engaging in scandalous circumstances.
Well, yes, she has to participate in the crime of concubinage.
Right, but a single woman could discover her lover is a married man, continue sleeping with him in discreet hotel rooms for years, and be guilty of absolutely nothing. Why? Because the married man isn't guilty of concubinage in that scenario, so she can't possibly be a co-accused.
That is a loophole, I'll admit.
The law is so desperate to protect the married man's private indiscretions that it inherently shields his mistress as well. But the unmarried man sleeping with a married woman, he's instantly a criminal the second he finds out. The asymmetry is dizzying.
It is a complex web, I agree. And the rigidity applies to the prosecution as well. If the unmarried man is innocent because he didn't know she was married, the wife can still be tried and convicted alone. The focus remains ruthlessly fixed on the married woman's breach of that structural biological boundary.
And even the concept of legal pardon is entirely twisted to favor the husband's authority.
How do you mean?
Well, a husband can pardon his adulterous wife, but as seen in People v. Zapata and Bondoc, that pardon only applies to previous acts, not subsequent ones. Furthermore, if he decides to pardon, he must pardon both the wife and the paramour.
Right, he can't pick and choose.
Exactly. He can't just forgive his wife and prosecute the other man. It treats the wife's sexuality as a piece of property that the husband alone governs and dispenses justice over.
Well, that is because these crimes are considered private crimes. Historically, adultery and concubinage couldn't be prosecuted de officio, meaning the state couldn't just investigate and prosecute them on its own behalf. The case of Semelin versus Court of First Instance explains why. The law exercises profound consideration for the offended party, usually the husband, who might prefer to suffer the outrage in private silence rather than go through the massive scandal of a public trial.
Oh, to protect his ego.
To protect his honor. The state doesn't kick the door down, because exposing the infidelity might cause more harm to the husband's public honor than the affair itself. The state leaves the keys to the prosecution entirely in the hands of the offended spouse.
But the keys to prosecution are completely different depending on whose hand is holding them. A wife holding those keys has to prove her husband practically put up a neon sign pointing to his infidelity. She has to catch him cohabitating or acting scandalously. A husband holding those keys just needs to find a misplaced love letter or catch her at an assignation house.
We have unpacked a tremendous amount of legal doctrine today.
We certainly have.
To summarize my position, the framework governing crimes against chastity, specifically the sharp distinction between adultery and concubinage, is undeniably harsh and heavily asymmetrical. However, it operates on a strict, cold, biological pragmatism. It was designed to protect the integrity of the family lineage from the irreversible introduction of spurious heirs at a time when paternity could not be scientifically proven. It prioritizes structural preservation over moral parity.
And to summarize my position, that very framework strips the marital vow of its essential mutuality and shared respect. By hiding behind the guise of biological pragmatism, it creates a convoluted, hypocritical system of scandalous circumstances and cohabitation requirements. This essentially legalizes male infidelity, provided it is kept reasonably quiet, while ruthlessly penalizing female survival indiscretion and hardship.
Despite our deep disagreement on the fundamental justice of this system, I think we have reached a very clear point of convergence.
I agree.
We both agree that these historical cases reveal a legal system that is deeply rooted in a very specific traditional conception of family honor, biological consequence, and public reputation. It is a snapshot of a worldview where the physical integrity of the bloodline supersedes the emotional equality of the partners.
Absolutely. It is a masterclass in how a society's values regarding gender and honor are quite literally codified into the mechanisms of prosecution and the very definitions of what constitutes a crime.
Which makes examining the specific language of the law so incredibly valuable. It allows us to reverse engineer the historical and philosophical priorities of a society. For those following along and interested in how these frameworks evolve, there is a lot more to explore in the material.
Oh, definitely.
It is genuinely fascinating to see how these older, strictly traditional legal doctrines regarding adultery and concubinage sit side by side with more modern definitions of gender-based crimes. We see this progression in later statutes, like Republic Act 7877 addressing workplace sexual harassment and Republic Act 111313, the Safe Spaces Act, which penalizes gender-based sexual harassment in streets and public spaces.
Yes, seeing that long evolution from a legal system that punishes women for surviving abandonment to modern laws specifically aiming to protect individuals from misogynistic slurs and unwanted advances in public spaces shows a remarkable ongoing tension in how the law views autonomy, vulnerability, and respect over time.
It certainly does. We will end our discourse here today. We leave it to you, the listener, to decide. Does the biological rationale of protecting a lineage justify the profound legal asymmetry we've discussed today?
Mm-hmm.
When we look back at the scales of justice, does that blindfold need to be securely tied to ensure absolute equality? Or does the nature of biology demand that the law peek out to see exactly who is standing on the scale? Keep debating.